For reasons mentioned in the judgment, the criminal petition is dismissed.
Very much of order, item number 1.
Here, the appeal is partly allowed. The conviction of the appellant under section 376 is set aside. Other conviction and sentence remain as it is. The appellant shall be released after serving out sentence. If he has already served out, he shall be released forthwith.
Highly obvious.
For reasons mentioned in the order, the prayer for bail is rejected at this time.
Briefly apply.
Maybe, Alosh. I would beg to mention for listing of a criminal petition for admission, my lord.
Listing senior court.
My lord,
Senior courts are there.
14.
Court number 11.
May I pray, madam? Item number 220 of today's list, madam. I am told by learned PP that the CD is not available. 20.
Heard Mr. A. Bhattacharya. Also heard Mr. D. Das, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. When, Mr. Das?
CD on 20th March to 8.
Release this matter on 20th of March.
May I please, Josh? I'd like to mention item number 54. Hearing.
Yes.
Today we have some difficulty. Let the matter be calm after 3 weeks.
Heard Mr. A.J. Hajorika, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. Let this matter be listed after 3 weeks.
Date may be fixed, madam.
No,
Hearing.
it is difficult to fix that. 3 weeks on a date to be fixed by registry.
I do. May I please, Lordship? I beg to mention item number 34 on behalf of Mr. D. Gogoi, Lordship. Here, D. Gogoi is amicus curiae, Lordship. He is not well today. Lordship, may I pray for an adjournment today and fix it
30.
on Monday, Lordship?
34.
34, Lordship. Only for today, Lordship.
You have informed the petitioner.
That, Lordship, I have not informed. I could not contact them.
You have to inform.
Yes,
We'll pass orders when the matter is called.
Lordship. Lordship, I beg to mention another item number 62. I have taken consent of the other side.
Item number
62. Here, Lordship, the respondent number 2 has already appeared and filed wakalat number. Mr. K.L. Gupta has entered appearance on behalf of respondent number 2. So, your Lordship may fix this matter for admission, Lordship. Supplementary item, Lordship. Supplementary cause list.
heard Mr.
R. Bora, Lordship.
R. Bora, learned counsel for the petitioner, who submits that in this case, you are praying for an adjournment today.
Lordship, the service of respondent number 2 has already been completed. Therefore, I'm praying for
Okay.
fixing the matter on admission.
The who submits that the respondent number 2 has notice issued to respondent number 2 has already been served, and Mr. K.L. Gupta has appeared as engaged counsel for respondent number 2. Hence, the matter may be fixed for admission. Release this matter for admission hearing in the next week on a date to be fixed by registry.
All right, Lordship. Much obliged.
My lord, in item number 57 of supplementary list, my lord, I have filed one additional affidavit today morning, my lord. Kindly, I may be allowed to bring this affidavit before your lord.
So CD to us.
I beg to mention for listing a criminal revision petition.
Listing senior court.
May I please, Lordship?
On the last episode, this court is to pass in water directing for also call of LCR, and I have entered before the registry. LCR has been received. Today's item number 40. Lordship may kindly call for 29 from the section
Item number
40.
40.
40. LCR has been received in the registry.
Find out 40 তাইছেন নে নাই খবর নেই। Okay.
11 February days.
May I please, Lordship? Lordship, I have considered the other side process, item number 11, Lordship, for adjournment.
Heard Miss R. Wrongmay, learned counsel for the petitioner who prays for an adjournment. She submits that
Fixed on April 7th, Lordship.
she has informed the learned counsel for the respondent regarding her prayer for adjournment. The prayer is allowed. Let this matter be listed on 7th of April.
7th of April, Lordship.
May I please, your Lordship. Lordship, I beg to mention item number 52, Lordship. Matter may be passed over for the day, my lord. The counsel for the appellant is out of station.
Heard Mr.
MM Zaman, on
M.
behalf of N Ahmed.
You are Mr. M.
MM Zaman, Lordship.
M. Jaman,
On behalf of N Ahmed.
submitting on behalf of N. Ahmad, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed.
Okay.
May I please, your Lordship? I beg to mention item number 29 and 30, both are connected matters, Lordship. The updated case diary was called, Lordship, with all the statements. I've been informed the updated statement.
Well, here your updated case diary was called, but the IO has not taken back the case diary. It is lying with us, and that is why it could not be updated.
Heard Mr. V. H. Chaudhary, learned counsel for the petitioner.
You have no.
Also heard Mr. D. Das, learned additional public prosecutor, who submits that though this court directed for updation of the case diary, however, the case diary was not collected by the investigating officer. Hence, he prays for some more time to get updated case diary. Prayer
On
is
4th of April.
let this matter be listed on 4th of April.
Should the interim be
The
kindly
interim order
14
shall continue till next year.
deeply obliged?
May I please, your Lordship? I beg to mention item number 27, Lordship. In this case, Lordship, today morning, I have filed additional affidavit. Let me call for.
Lordship, I have taken consent in item number 34. Just now.
34. Heard Mr.
Kimo number is it?
34.
Your R. Bora, learned counsel for the learned counsel appearing for Mr. D. Gogoi, learned amicus curiae, appearing for respondent number 2, who prays for an adjournment. He submits that he has informed the counsel for the petitioner, counsel for the appellant regarding his prayer for adjournment. The prayer is allowed. Let this matter be listed.
On any day first.
Okay, the prayer is allowed.
Right.
May I please, your Lordship? I beg to mention hearing item 48 to 51 with the consent of other parties may be adjourned. My senior
in this case, I'm the-
is out of station.
Then this is I'm for the respondent, Lordship. It may be fixed, Lordship. Pending since 2017, Lordship. Long pending matter, Lordship. It may be given, Lordship.
Heard, Miss, what is your name?
DL Deka.
GL Deka, learned counsel for the appellant who prays for an adjournment. Also, heard Mr. You are
SK Chetri,
appearing for
Enuddin.
heard Mr. SK Chetri appearing for Mr. Enuddin, learned counsel for the respondent. Considering the submissions made by learned counsel for the petitioner, the prayer is allowed. Let this matter be listed in the 4th week of April on a date to be fixed by registry.
Highly.
Ladies, motion be identified.
In this case, notice has been served. That's probably the option.
Notice is served.
Notice is served. I have.
Heard, Mr.
It-
R. Day, learned counsel for the petitioner. And case diary,
Case diary is not received.
also heard
Case diary
Mr.
medicine है लेकिन.
D.
File
Das,
is going well. Case diary probably will.
D. Das, who submits that
Okay, okay.
notice issued to respondent
This is
number,
from part of the record. Service report.
respondent number 2 has been duly served. He furnishes a copy of report of service of the notice furnished to him by the officer in charge of jurisdictional police station. Let the report be kept in the record as a part of record. As none has appeared for the respondent number 2, this court intends to appoint an amicus curiae. Mr. Nawaz, you act. Mr. S. Nawaz, learned counsel whose name appears in the list of amicus curiae is hereby appointed as amicus curiae for the respondent to defend the cause of respondent number 2 in this bail application. The petitioner is directed to furnish copy of bail application along with annexures to the amicus curiae. The registry is directed to reflect the name of learned Mr. S. Nawaz as amicus curiae for respondent number 2 in the cause list henceforth. When we can fix?
Because already Miller since 22/10/2024 is behind bar Miller. Not so kindly considered in.
What is the status?
Only the IOA is required to be examined. Miller. The others witnesses have been examined.
You have annexed the,
I have certificate copies Miller, but it's very vernacular Miller. I didn't. Otherwise, I have the certificate copies.
okay. When can we take it?
Any day next week, Miller.
Let this matter,
I'll furnish.
let this matter be listed again on 20th of March,
20 April, no? 20 March.
20.
I can forward.
May it please your lordship. In this matter, your lordship on the earlier occasion has granted interim bail to the petitioner and directed him to appear as per the notice under section 67 before the NCB. The petitioner has appeared on 11/2/2025. Your lordship, on the last occasion. And in fact, the Jimma of the veneer of the petitioner's meal have also been granted in the Jimma order. The court has also stated that he has cooperated with the inquiry and the veneer and other log products are of the petitioner, so the Jimma has been given.
Lordship, his statement has been recorded, involvement is not there.
Not there. Okay. Heard Mr. Y.S. Mannan, learned counsel for the petitioner. Also heard Ms. M. Deka, learned counsel appearing for NCB. Learned counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail by order dated 6/2/2025 by this court, and in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. On the other hand, Ms. M. Deka, learned counsel for the NCB, has produced the case diary of NCB, connected NCB case, and has submitted that the statement of the petitioner has been recorded and no incriminating material has been found against the present petitioner. In view of above submissions, the interim anticipatory bail granted to the petitioner by order dated 6/2/2025 is hereby made absolute.
Obliged.
Highly obliged.
I can cite.
May I please your lordship. Lordship, this
Matter relates to the Jimma of 3 numbers of mobile matter of the petitioner and other articles matter. At this stage matter, report may be called for from the STF police station matter.
Heard Mr. J. Ali.
Yes, ma'am.
Learned counsel for the petitioner, also heard Mr. D. Das, learned additional public prosecutor. This application under section 528 of BNSS has been registered has been filed by the petitioner impugning the order dated 30/1/2025 passed by learned Chief Judicial Magistrate Kamrup Metro on petition number 5541 arising out of STFPS case number 20/2024, whereby the prayer for Jimma of the seized mobiles and other articles was rejected by the said court. Stop. Let a report be called for from the investigating officer of STFPS case number 20/2024 as to whether the seized articles are still required for the purpose of investigation and whether the Jimma of the same may be granted to the petitioner or not. Let this case be listed again on 25th of March. 25th of March.
On 4th of April.
4th of April.
STF code.
4th of April.
Well,
Next item.
Matter, this month matter, this one, the STF matter.
4th of April.
I'm applying. Worship, please.
87 and extra 7. I'm here because this court has now issued NBW to both the petitioners. I have been constantly appearing. From 15th of March, this matter was transferred. Initially, the matter was registered in Teju. From Teju, it came to Konsa. From Konsa in 2021, Your Lordships, this High Court has now passed an order the matter to be tried here in Assam, Sessions Court. So CBI. Now, 2021, my lord, that was the order passed by the High Court, which I have annexed. 2021 till today, all the orders that I have relied on, which I'll read it through, Your Lordships, indicate that no summons were ever sent to me. In fact, this order also, Lordship, which has been passed, the request made by the council also was for issuance of a summon. Unfortunately, the second part of the order is what is creating a problem. May I just read?
Which order? Which?
Page 87 and extra 7. That's the order that I'm here before this question.
Page 87.
Page 87 and extra 7. May I just read, Your Lordships? 4/2/2025. Today, it was fixed for appearance of HIO special PP as per the proceedings at 19/12/2024. For a long time, the prosecution was not appearing. So that's the order it is. CBI is represented. Today, so-and-so, the special crime Kolkata is also present. Prosecution has submitted a petition stating that the accused Mr. So-and-so have been appearing has not been appearing in the trial court since 29/7/2020. Besides, accused so-and-so and so-and-so have also not been appearing in the learned court since 17/6/2019. And as such, their appearance are needed for due process of law. It is prayed to issue process against this accused for their appearances. The petition is allowed. Next, it says issue MBW to Mr. Muiva and Luikham and so-and-so.
Who are you?
I am number one, Muiva, and secondly, Luikham. Both of us are in bail since 2015, appearing till 2019. Matter was transferred from Konsa to now to Assam. So no summons have come till date. All the previous orders reflect that the IOs have not appeared for whatever reason they did not. Now they have appeared. So all I'm saying that this is.
Okay, when is the date? Yes,
Lordship may issue notice, Lordship.
No, let them appear. Why to
No,
link?
they may appear, Lordship. Let us give, Lordship may kindly give us a chance to kindly file and reply to it, Lordship.
No, why reply is necessary? When the materials before us is apparent that no summons was issued to the petitioners.
No.
the court required their presence only.
Correct, Lordship.
Yes,
That is
and I'm ready to
If,
appear.
if they are ready to appear,
Yes,
why?
Lordship, my prayer may be recorded and Lordship may pass it on.
Okay. Heard, Mr. What is your name?
RB Fukan.
Heard Mr. R.B. Fukan, learned counsel for the petitioner. Also heard Mr. M. Haloy, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioners, namely Hormi Muiva and Reshang
Raishan.
Luikham, who are impugning the order dated 4/2/2025 passed by learned Special Judge CBI Assam within bracket additional court number 3 in KSA/Sessions case number 226/2021, whereby non-bailable warrant of arrest were issued against the present petitioners. Learned counsel for the petitioner has submitted that the petitioners this case was earlier pending before the Court of Learned Session Judge Khonsa and
First Teju, then Konsa, now transferred here.
Teju, Learned Session Judge Teju, and thereafter it was transferred to the Court of Learned Session Judge Teju. Stop. Thereafter, as per the order passed by this court, which order?
Yes, my lord. The transfer order is at page annexure 5, page 65. That's the High Court order.
As per the order
5321.
passed by a coordinate bench, passed by this court on 5/3/2021 in transfer petition within bracket criminal number 8/2020. The KSA Sessions case number 226/19 was transferred to the Court of Learned. Which court?
Special Judge,
Learned Special Judge
CBI Assam.
CBI Assam. Learned counsel for the petitioner has submitted that the petitioners were granted bail by the court. Which court?
Yes, good, this court, your lordship. It's on 18/6/2015. That's page 25.
Page number.
Annexure A2, page 25.
Bail in the above noted case by this court by order dated 18/6/2015.
18/6/2015 is the order.
2015 in bail application number
Page 28 is the relevant part.
875/2025. Learned counsel for the petitioner has also submitted that thereafter, after transfer of the case to the Court of Learned Special Judge CBI Additional Court number 3, the petitioners never received any summons from the said court.
Good.
He also submits that even the orders passed by this Court of Learned Special Judge CBI number 3, Additional Court number 3 would reveal that no summons were issued prior to issuance of non-bailable warrant against the present petitioners on 4/2/2025. Learned counsel for the petitioner submits that petitioners are ready to face the trial and they are ready to appear before the trial court on next date fixed, that is 24/3/2025.
Great.
However, some protection, petitioners are seeking some protection, interim protection, so that as non-bailable warrant of arrest have already been issued against them. On the other hand, Learned Special Public Prosecutor CBI submits that notice may be issued at this stage and records may be called for. Stop. I have considered the submissions made by Learned Counsel for both the sides and have perused the records, You have annexed the orders of the court.
Yes. Page 79, it starts, annexure 6. And the previous orders are also annexed.
Summons were never issued.
No, from the time it has come to here,
Stop.
no.
On
That's my,
on perusal of the orders passed by the Court of Learned Special Judge CBI in additional court number 3 in KSA/Sessions case number 226/2019, copies of which are annexed along with this criminal petition, it appears that the trial court has never issued any summons to the present petitioner and
What
on
if his submission is his trial code of this, I mean to say the,
this court,
this code?
trial court within bracket लिखिबो Sessions Judge CBI, Special Judge CBI within bracket additional court number 3 stop. And on 4/2/2025 directly issued non-bailable warrant of arrest. Stop. Since the petitioners are ready to appear before the trial court and ready to cooperate in the trial, and since they are already on bail, this criminal petition is disposed of with a direction to the above named petitioners to appear before the Court of Learned Special Judge CBI Assam within bracket additional court number 3 in KSA/Sessions case number 226/2019 on the next date fixed before the said court, that is on 24/3/2025. Stop. To facilitate their appearance before the trial court, before the said court, the operation of non-bailable warrant of arrest issued against them shall remain suspended. On their appearance before the trial court, the petitioners may file appropriate application seeking appropriate relief before the said court, if so advised.
only one request. I may be allowed to remain in the previous bail conditions because that has been quite recent. 10 lakhs has been paid.
No, your bail is not rejected.
Yes, please. That is my only
You have to
request.
make this prayer before the trial
I'll do that.
to recall the
No,
this
no problem.
criminal petition is accordingly disposed of.
Grateful, please. Grateful.
Mr. K. Chaudhary will appear in this matter, my lord. Can it be taken up after some time, my lord?
Okay.
Lordship, in this case, NBWA followed by a PNA was issued against the petitioner for remaining absent before the learned trial court, my lord. Lordship, the petitioner, since 1.5 years, he is staying in Meghalaya. He is a construction laborer, my lord, and none of the process was served upon him personally, Lordship. Now, Lordship, he is willing to participate in the trial, my lord.
No, but you defaulted on your own. Where is the, when is the next date fixed?
Lordship,
When is
the
the,
next date is fixed on 3rd May, my lord. 3/5/25, 3rd May of 25. I'm willing to participate in the trial.
heard Mr. M. Zaman, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. What is the offense? Oxon. Have you appeared earlier?
No, my lord, I have not
You have
appeared.
never appeared.
No, I was never appeared. Because, Lordship, I was unaware about the case, my lord. I'm not at all aware, my lord.
This application under section 528 of VNSS has been filed by the a petitioner impugning the order dated petitioner, namely Asraful Islam alias Ashriful Haq, who impugning the order dated 24/7/2024 and subsequent orders passed in special POXO case number 31/2024, whereby non-bailable warrant of arrest and orders for proclaiming him as absconder and attachment of his property were issued. Learned counsel for the petitioner has submitted that the petitioner is a daily wage laborer and he went to Meghalaya in search of his livelihood. He also submits that the petitioner has never received any summons from the trial court. However, he is ready to face the trial and ready to appear before the court on the next date fixed. That is on next date is
3rd May, my lord.
that is on 3rd May 2025. I have considered the submissions made by learned counsel for both the sides and perused the materials available on record. As the petitioner is ready to face the trial, this criminal petition is disposed of with direction to the petitioner to appear before the Court of Learned Special Judge Gwalpara in special POXO case number 31/2024 on the next date fixed, that is 3/5/2025, and to facilitate his appearance before the trial court on that date, the non-bailable warrant of arrest issued against him by the trial court shall remain suspended till 3/5/2025. With above observation, this criminal petition is disposed of.
Actually, the order of PNA may also remain suspended.
You go and pray before the trial court.
My lord. Deeply obliged.
Dispose of it.
Obliged.
Applicable lordship. 482 application lordship, the FIR has been lodged under section 51 of Copyright Act, 63, 65 of Copyright Act, along with 318 of BNS Act lordship. The FIR is on page 17.
What is 318?
Lordship 318 of BNS Act for cheating. Along with 51 of copyright, 63 and 65 of copyright act. That's infringement of copyrights.
What is the accusation?
Accusation, lordship, the complainant is a Century Plywood.
Where is the FIR?
FIR is
Contents are 19.
page 17 starts annexure 2. Page 19 is the content of the FIR law, which is lodged on 3rd February 25, lordship. The operative part is the last paragraph, lordship. Recently, we came to know that some manufacturers, suppliers, wholesalers, dealers in the jurisdiction of Kochu police station are supplying spurious imitations and inferior quality plywoods, plyboards and blockboards under the name GLP, Canon Club Prime, which is deceptively similar to our copyrighted brand GLP and registered trademark Century Club Prime. Lordship, the petitioners herein are only the retail distributors of the plywoods. They are not the manufacturers. The following page, lordship. The registration with both the copyright and trademark department gives the company exclusive right to use the trademark for its own use. The spurious
Where are you reading?
Lordship.
Page 20. Which page you are reading?
Page 20, lordship. Following the following page of the FIR.
Page 20, which read? Please read.
First paragraph, lordship. The continuation from page 19, lordship.
Okay.
Yes. They have alleged that the registration with both the Copyright and Trademark Department gives the company exclusive rights to the use of the trademark name of its own use. These spurious plywood boards look like cheap imitations of our famous registered brand GLP Century Club Prime, having this deceptively similar design. We state that the supplier is supplying for the purpose of trade, infringing copies of renowned GLP copyright in the artistic work, thereby affecting the exclusive right of the complainant within the meaning of Section 51, Section 63, 65 of the Copyright Act 1957. The copy of the copyright registration attached, which is not a part of the record, lordship. In this lordship, the petitioners are the partners of the firm, which is the retail distributor. We are only the stockist and retail seller of the product which has been manufactured by the Kanan company, which is Bengal Industries, lordship. And subsequent to the lodging of the FIR, lordship may come to Annexure 3, page 23. These are the copies of the invoices where we have purchased these materials from Bengal, not Bengal Industries, for the purpose of retail sale.
Okay.
And lordship, then
Now, what is the submission?
lordship, we are only the distributors, retail sellers of the product. We are not manufacturing. We are not imprinting anything on the plywood. We are nowhere involved in the activity, if at all the allegation is true. But only because they have named in the FIR indirectly that the supplier, wholesaler, dealer, we got involved. And subsequently to the filing of the FIR, the goods have been seized from our godown, lordship. The seizure memo starts from page 27, Annexure 5. This is the seizure memo. The place of seizure, the second paragraph, godown of Saraf Plywood Agency
Yes,
LLP.
Mr. Das.
Lordship. And
Yes,
similar matter, lordship, yesterday has already given an imprint to the manufacturer
Okay.
in AB.
Where is the order?
Lordship, that order is not yet uploaded. Yesterday, we moved that.
Heard Mr. A. Todi, learned counsel, petitioner. Also heard Mr. D. Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioners, namely 1, 2, 3, 4, Yarpa Naam Likhito. Petitioners who are apprehending their arrest in connection with Gorsup PS case number 54/2025 under section 318 of BNS, read with section 63/65/51 of the Copyright Act 1957. The gist of accusation in this case is that 1. Chetna Khanna had lodged an FIR on what is the date of the FIR?
That was filed on 3/2, but
3/2,
registered on
3/2/2025.
yes, registered on 17.
Inter alia, alleging that the manufacturer, suppliers, wholesale sellers, dealers in the jurisdiction of Gorsup are supplying spurious imitation and inferior quality of plyboards and blackboards under the brand name within inverted comma GLP / Canon Club Prime, which is deceptively similar to the copyright brand within bracket GLP of the first informant. So it is alleged that by imitating the copyright, the said manufacturers, suppliers, wholesalers, dealers are cheating the general public stuff. Learned counsel for the petitioner has submitted that the petitioner are only the distributors of plyboards and they are in the business of retail dealership. It is submitted that the petitioners are not manufacturer of the plyboards and therefore even if the allegations made in the FIR is treated to be true, the petitioners are not liable for violation of any provisions of Copyright Act stuff. Petitioners further submits that in the meanwhile, some of the co-accused have already been released on bail, released on interim bail by this court. When is the date fixed?
28th March.
Stop. He further submits that the petitioners are ready to cooperate in the investigation. On the other hand, London Additional Public Prosecutor submits that the case diary has already been called in other cases and same is fixed on 28th of March. Therefore, case diary may also be called for in this case. List this matter on 20th. Call for the case diary. List this matter on 28th of March. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed herein above, the above named petitioners are directed to appear before the investigating officer of Gorsuk PS case number 54/2025 and cooperate in the investigation stuff. If they do so within the stipulated period of time, in the event of their arrest in connection with the aforesaid case, the above named petitioner shall be allowed to go on interim bail of ₹30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Let this case be listed again on 28th of March.
Much of.
I think 57 from supplementary is.
Affidavit has not arrived.
Yes, my lord, but I have extra, it's coming, my lord, I have extra, my lord, should I have yes, my lord. It is on the way, my lord.
Or let it come, we'll take it up after some time. After some time.
My lord. Oblige.
Affidavit to Ahile it will also. Can copy. I say. Yes.
May please, Your Lordship. My lord, this is a case where the petitioner was arrested, my lord, in connection with an NDPS case, my lord. Now the arrest, my lord, having been made on, my lord, 29/8/23. As on date, my lord, the incarceration is about 18 months, 11 days, my lord. 13/3/25. And your lordship will also take note of the fact, my lord, that the charge sheet, this was laid before the court on 31/12/23. And there is hardly, my lord, any progress with respect of the trial, my lord.
What is the progress?
Perhaps, my lord, the trial has not taken place, my lord, yet.
Charges are framed.
Yes.
And how many witnesses are there?
Witness, my lord, there are eight witnesses.
How many have been examined?
Get examined.
The last question referred to was Judicial. My lord, on 5/10/2024, my lord, one witnesses were present, my lord, but he could not be examined, my lord.
So till date, virtually, my lord, there is no examination of witnesses, my lord.
What is the contraband?
Contraband, my lord, is
methamphetamine, 996 grams. 996 grams.
Mr. Talukdar, you are not prepared.
no, I am prepared, my lord. 996 grams, my lord, of
Methamphetamine.
methamphetamine, my lord. Tablets, my lord, Yaba tablets, which contains, my lord, that
What is the commercial quantity of methamphetamine?
250 grams.
250 grams.
my lord, he is a commercial quantity in this case. It's admitted, my lord.
Yes, Mr. Borwa.
Madam, my humble submission, my lord. Yes, my lord. My learned prayer is correct, my lord. Charges submitted, my lord, and 25/6/2024 charges framed, my lord. Thereafter, my lord, witnesses are someone has been issued regularly, my lord. Witnesses are not turning up, my lord. Although, my lord, on 5/10/2024, one prosecution witness was present, my lord, but he could not be examined, my lord. And as part of my lord, last report, my lord, the case was fixed on 19/2 for evidence.
Heard Mr. S.K. Talukdar, learned counsel for the petitioner. Also heard Mr. R.J. Borwa, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Ishub Ali, who has been detained behind the bars since 29/8/2023 within bracket for last 1 year, 6 months and 8 days in connection with special NDPS case number 113/2023 pending before the Court of London, Sessions Judge Karimganj within bracket Sri Bhumi, Session Judge Sri Bhumi. The gist of accusation in this case is that on 28/8/2023, one Shafiqul Islam Majumdar, SI of police, had lodged an FIR before the officer in charge of Badarpur police station, inter alia, alleging that on receipt of an information through reliable sources to the effect that two persons carrying huge quantity of contraband were coming from Silchar side to Badarpur on a motorbike bearing registration number AS11T1113 stop. Accordingly, a search team was constituted and a Naka was arranged. Naka was set up at National Highway number 37 at Alakulipur, Alakulipur. During Naka operation, the motorcycle bearing registration number AS11T111 was intercepted, and the riders, two of the riders of the motorbike, including the present petitioners and one Nasir Mia, were apprehended. On search of the motorbike, 996 grams of Yaba tablets suspected to contain methamphetamine were recovered from there. Learned. After completion of the investigation, charge sheet was laid against the above named petitioners on 31/12/2023. Stop. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars since more than 1 year, 6 months. However, till date, not even a single witness, prosecution witness out of 8 listed prosecution witnesses have been examined. We therefore praise for allowing the petitioner to go on bail. Fourth paragraph number 7 from bail application number 329/2025. Para 8. Then I have considered the submissions made by learned counsel for both the sides and perused the materials available on record, including the scanned copy of the case record of special NDPS case number 113/2023. Code para 10, 11, 12, 13. 14, 15, 16, 17. From 329, bail application 329/2025. Bail amount instead of 2 lakhs, 1 lakh. 1 lakh with 2 sureties.
My objection may be recorded.
I have recorded.
Deeply obliged.
Aile mati.
Your Lordship already seen this matter earlier, madam. What happened in this case, madam? This victim, he was examined, madam, initially. And whenever it was found that madam, she may speak something like favor.
It is a POXO case.
Yes, yes.
He is appearing for informal.
Yes.
Yes. Now kindly see the FIR, my referee.
At
That
page,
your Lordship may refresh the date here. Page 1.
it is a charge sheeted case.
Yes, charge to the case.
Victim has not been examined.
A half by the chief already done. Thereafter, you're from 19-1, the matter is kept pending, madam. Father, madam, father.
That has not come, my lord. Only the case that he has come, my lord.
As per my instruction, Lordships, case is pending for last date, the other 2 cases appeared, Lordships.
What is the accusation against?
Lordships.
What is the allegation against you?
Earlier it was 307, later on it is 302 Lordships. Its main fact is, my lord, actual fact is the case is that, Lordships, and the deceased had the affairs with the accused number 1, Lordships. And she has come to the house of the accused number 1 that would allege that he married with that woman. She is a married girl, married lady, Lordships, and he was not maintaining her. Thereafter, some villagers came out and they decided that yes, showed the proof, but she could not show the proof. Thereafter, my lord, another meeting was held. That also she could not show any proof, Lordship. Later on, she has committed suicide, Lordships. And this is colored as 302, Lordships.
Postmortem examination.
It is, my lord, burn injury, my lord, and there is a dying declaration, my lord.
She has implicated.
Yes.
My lord, my submission is that I am behind the bar for last 122 days. Substitute file, Lordships. So, my lord, keeping me behind the bar, no purpose will charge, Lordships. I am ready to face the trial, Lordships.
In that trial, actual fact will come out, Lordship.
My lord, let the status report be called for, my lord, because it is not known by what is the present status of the case, my lord.
What is the status of the trial?
My lord, just appears completed, Lordship.
Whether charges?
No, that is not. That is not. Case has been committed from the JMFC to Learned Session Judge, Lordships. Well, my submission is that, Lordship, keeping me behind us, Lordship, no purpose will serve, Lordship, because already such is submitted, Lordships. Your Lordship may impose any condition, Lordships. I will face the trial, Lordship. And kindly see the one is lady, Lordship. She is
No, but
about 58 years old, Lordships.
if you are involved in the offense, you may evade the course of justice. Flight tricks is there.
Let us face the trial, Lordships. Your Lordship may impose any condition, Lordship. We are local people, Lordships. And mother and son, Lordships.
Where is the FIR?
Yes, Lordship. There is Lordship, page 11, Lordships.
Next item.
Okay, no, let us first call a status report.
Yes, my lord, that would be better, my lord.
After that, we will consider your,
There are
because
my lord, there are 4 accused persons, 2 already granted by your Lordship industry bail, and these persons were rejected by your Lordships. So, my lord, they were arrested, Lordships.
where is the rejection order?
Yes, Lordship, that is. Lordship, page 28, Lordships. All our family members, Lordship.
Yes, therefore, status report would be necessary. Heard.
M. Hawk.
Mr. M. Hawk, learned counsel for the petitioners. Also heard Mr. R.J. Barua, learned additional public prosecutor. The scanned copy of the case diary of Goreshwar PS case number 30/2024 has been received. However, considering the facts and circumstances of this case, as the charge sheet has already been laid, let a status report of the trial be called for from the trial court. The prayer for bail may be considered after receipt of the status report of the trial. Registry to take steps for requisitioning the status report. Let this case, when is the next date fixed?
Next video. There is
Let this case be listed again on
kindly give us short date, Lord.
28th of March.
Kindly before that, Lord, because it is here, Lordship. It is coming, Lordship.
28th March.
I want that.
May I please the Lordship? Lordship, this is NDPS case of Nalbari of case number 13/2024, and the accused is behind a bar for 487 days. Lord. That's the case, Lordship. Already there are 15 witnesses. Already 4 are already examined. Lord.
487 comes to 1 year.
16 months. 487 days. 16 months.
And your ground is
So the
long incarceration. On what ground you are seeking bail?
Lordship, from the PW1, Lordship,
No.
PW2 and PW3,
Yes.
they are the independent witness. They are made hostile in this case, Lordship. And moreover, Lordship, the accused has been languishing before the bar since 16 months, and there is no hope of early culmination of
16 months is not a long time.
Moreover, this court has already given a bail to a co-accused, Lordship.
Show me. Where is the bail order?
Page number 62, Lordship. Annexure 6.
On what ground bail was granted?
Given in pair number 7, that there is total 15 listed prosecution, five has already been examined, none of it are integrated.
Relying on Tufan Singh, my lord, he was drafted.
Tufan Singh case also.
But in your case, what is your name?
Topon Mohan Tolor, sir.
Tapan Mahanta. You, from your possession, from your house, the contraband was seized. So you will not get benefit of Tufan Singh.
Yes. Also, but this is a case, this is a fit case for the accused to get acquitted. Lord.
Why fit case?
Because 2 of the independent witnesses are already
No,
hostile.
out of how many witnesses?
15 witnesses, 4 are already examined.
Still 11 witnesses are yet to be examined. What they will depose, nobody knows. Yes, Mr. Burra.
My lord, it was, my lord, recovered from their house, my lord. It was hidden in a, my lord, cow set, my lord. And my lord, out of the 15 witnesses, my lord, 5 witnesses examined, my lord. The PW5 witness is not completed, my lord, PW5. My lord, there are materials, my lord, it was recovered from their consent position, my lord. So, my lord, I oppose this bail application at this stage, my lord.
Even Lordship, the cow shed is 10 meters away from the home of the accused, Lordship. As we repose in page number 55, Lordship, in the cross part, Lordship.
No, that we will not consider now.
It will fully cooperate with the trial, Lordship.
Heard, Mr. What is your name?
P.D. Bhingan.
P.D. Bhuyan, learned counsel for the petitioner. Also heard Mr. R.J. Borwa, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, Shri Tapan Mohanta, who has been detained behind the bars since 12/11/2023 for last 16 months in connection with NDPS case number 13/2024 corresponding to Mukalma PS case number 561/2024 under section 22C/29 of the NDPS Act. The gist of accusation in this case is code paragraph number 3 from page 63. Para 4, para 5. Learned counsel for the petitioner has submitted that the petitioner has been languishing behind the bars for last 16 months and only 5 out of 15 listed prosecution witnesses have been examined, and there is no hope of early culmination of trial, and therefore he prays for allowing the petitioner to go on bail on the ground of prolonged incarceration. He also submits that in the meanwhile, this court has already granted bail to one of the co-accused, namely Saddam Hussein, in bail application number 3854/2024 on 10/2/2025. And therefore, he may also be allowed to go on bail. The learned counsel for the petitioner further submits that the independent Caesar witnesses, 2 of the independent Caesar witnesses who have been examined have not made any incriminating, have not made any implicating statement against the present petitioner. On the above grounds, he prays for allowing the petitioner to go on bail. On the other hand, Mr. R.J. Borwa, learned additional public prosecutor, has submitted that total 38,880 number of sparse Trancan plus capsule were found from the residential premises of the present petitioner, he further submits that as the quantity of contraband seized in this case is of commercial quantity, embargo of section 37 of the NDPS Act is applicable in this case. He further submits, learned additional public prosecutor further submits that the petitioner does not stand on the same footing as that of the co-accused who has already been granted bail, as because the co-accused was mainly granted bail on the ground that only material against the co-accused was the statement of the accused persons recorded under section 67 of the NDPS Act. Whereas in case of the present petitioner, the contraband was recovered from the residential premises of the present petitioner. Hence, he submits that both stands on different footing. He therefore prays for dismissing the bail application. I have considered the submissions made by learned counsel for both the sides and have gone through the scanned copy of the case record of NDPS case number 13/2024. It is not disputed that the quantity of contraband seized in this case is of commercial quantity. Hence, apparently, the embargo of section 37 of the NDPS Act is applicable to this case. Regarding the plea of prolonged incarceration taken by the petitioner, taken by learned counsel for the petitioner, this court is of considered opinion that considering the quantity of contraband seized in this case, incarceration for 16 months may not be regarded as long enough so as to give the benefit of bail on the ground of prolonged incarceration to the present petitioner. As regards submissions of the learned counsel for the petitioner to release him on the ground of parity, it appears that as submitted by learned additional public prosecutor, the petitioner and the co-accused who has already been released on bail do not stand on same footing. In case of the petitioner who has been, in case of the co-accused who has been released on bail, the seizure was not made from his possession, whereas in the case of the present petitioner, the seizure of contraband has been made from the residential premises of the present petitioner. So, in view of above, this court is of considered opinion that at this stage, the petitioner has not been able to overcome the embargo of section 37 of the NDPS Act. Therefore, the prayer for bail is rejected at this stage.
Lordship, kindly fix this matter at 2 p.m. Lordship. Lordship, engage counsel is on legs in another day. Mr. S. Lordship, kindly at 2 p.m. Lordship.
2 p.m. tomorrow on Monday.
Then password for the time being, Lordship.
Okay, that prayer may be.
Lordship.
23. Huh? My lord, I am intimated that my lord Kesari is on the way.
Kesari has not yet been reached.
Has not been reached. Let
Then-
it come up at 2 p.m. We'll see.
Okay.
DA.
May I please, Lordship?
The Kesari was called for Lordship.
Kesari received.
Just to question.
Lordship, the petitioner was arrested
What is
on Lordship 15/2/2025. Lordship.
15-2?
Yes, Lordship.
How many days behind the bar?
26 days behind the bar.
What is the offense?
Lordship, it is alleged to be, it is alleged that the 124 grams suspected to be heroin found in from possession of the.
124.
Yes, Lordship.
What is the progress of
Intermediate Lordship.
Intermediate quantity.
However, Lordship, it is in his conscious position, the heroin is found, Lordship. Moreover, the independent witnesses implicated him, Lordship. And Lordship, he himself had admitted that he deals in the business of doing this drugs dealing, Lordship. And he has get 2,000 rupees if he sell the pops. It is also stated here, Lord.
now whether investigation is remaining or it is over?
It is going on, Lord.
So
To look into the person from whom he has purchased this
that aspect is not.
drugs, Lordship.
Okay.
It is going on that line, Lord.
How many days?
26 days.
It is too early for 126 grams. It is a
Lordship, if FSL not received, then Lordship may keep the bail application pending, Lordship, for FSL will wait.
FSL has been received.
FSL, I have not received, Lordship. But
Why you are
it is
saying that it is not heroin? It may not be also,
May not be, Lordship.
but that you have to say.
But he has not said that, Lordship, when he say. Moreover, the case is not pending for FSL, it is pending in different line, Lord.
What is your submission?
My submission, Lordship, I am falsely implicated into this case, Lordship. Nothing has been found in my possession, Lordship.
That we can
Yeah.
verify from the
Implicated, Lordship.
heard
In-
Mr. K.
Thakur,
Thakur, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner Salim Ahmed, who has been detained behind the bars since 15/2/2025, within bracket for last 23 days, in connection with Basishta PS case number 103/2025 under section 21B of the NDPS Act 1985. The gist of accusation in this case is that on 14/2/2025, one Biplab Roy had lodged an FIR before the officer in charge of Vasishta Police Station, inter alia, alleging that that an information was received by the received regarding peddling of huge quantity of NDPS narcotic drugs in Balughat area under Basishta Police Station. Accordingly, a team of police officials, police personnel were constituted, and it went to the Balughat area. On arrival at that place, the police noticed one person carrying a brown color leather bag, arm bag, who was moving in a suspicious manner. On interrogation, he was found to be the present petitioner. When his leather bag was searched, 123.46 grams of suspected heroin was recovered from his possession. learned counsel for the petitioner has submitted that the petitioner is innocent and nothing was recovered from his possession, and he has been falsely implicated in this case. He further submits that considering the period of detention, the petitioner may be allowed to go on bail. On the other hand, Mr. K.K. Das, learned additional public prosecutor, has vehemently opposed the grant of bail to the petitioner at this stage. He has produced the case diary of Vasishtha PS case number 103/2025 and has submitted that there are sufficient incriminating materials against the petitioner in the case diary, and investigation is still progressing to find out the source from where the contraband was procured. Stop. I have considered the submissions made by learned counsel for the petitioner, learned counsel for both the sides, and have gone through the case diary of Vasishtha PS case number 103/2025. There are sufficient incriminating material against the petitioner as the witnesses examined by the investigating officer till date implicate the petitioner, and there are material to show that the seized contraband was recovered from the possession of the present petitioner. Since the investigation regarding source of the said contraband is still going on, and only 23, and the petitioner has been detained behind the bars since 15 to 25 only. This court is of considered opinion that at this stage it is not a fit case to give the benefit of bail to the petitioner. Hence, the prayer for bail is rejected.
May I pray, Lordship?
Send back the
May I
case
allow to
then.
withdraw, Lordship?
You should have withdrawn earlier.
Yes.
Not now. I have already declared.
Keep establishment.
Rest.
12-3, my lord. 12-3-23, 22, 23, my lord. Yes, my lord, what happened in this case, the police, my lord, intercepted one Maruti vehicle on 10/3/2023. From that vehicle, my lord, they recovered 1 kg 274 grams of suspected heroin, my lord, from 3 occupants of that vehicle, my lord. If I may take a lordship to page 16, my lord, at moment. 3 persons were there, my lord, in that vehicle: Kabir Ahmad, Atabuddin, and Abdul Qadir. I am not the occupant, my lord. So they were arrested.
You were not there in the vehicle.
Yes, my lord, I was not there in the vehicle. These 3 persons were, my lord, there in the vehicle. They, the police intercepted them and recovered the contraband, my lord.
How much?
It's 1 kg 274 grams, 75 grams.
How you are connected?
Yes, my lord. I have flag marked the forwarding report. There also, my lord, I could not find any implications against the present petitioner.
Page number?
Forwarding, my lord, this is in the record. I have marked that with a blue flag, my lord. Blue marking is blue flag is blue.
What is the?
Yes, there also, my lord, I could not find.
You are Badrul Islam.
Yes, my lord, Badrul Islam. There also, my lord, I could not find the implication of the present petitioner. Only thing, my lord, when the charge sheet was laid in this case on 36/2023, at page 31, my lord, if I may request the lordship, page 31. 5th paragraph from bottom. Fifth paragraph from bottom, my lord.
Fifth paragraph from. book.
Yes, during interrogation, the chief has got it, madam.
Yes.
Yes. During interrogation, the arrested accused person revealed that one co-accused, namely so and so, that is the present petitioner, Karimganj, is also involved into the conspiracy to trafficking the narcotic items. So this is the allegation, madam. He was arrested, which I came later on during the filing of charge sheet, that I was arrested based on the statement of confessional statement of co-accused. Now, my lord, that thereafter the learned trial court was charge sheet was laid, citing 9 witnesses in this present case, madam, to prove the prosecution case. And on 10/11/2023, the learned trial court was pleased to frame charges against the present petitioner along with others, my lord. And till date, my lord, there was no examination of witness, which is the no PW, my lord, turned up. And as such, the my lord, the trial could not be, trial is not proceeding against the present petitioner, my lord. And on my lord, page 35, the co-accused persons, my lord, from whom the contrabands were recovered, they approached this honorable court, and my lord was pleased to allow their prayer of bail by order dated 17/2/2025, considering the my lord prolonged incarceration, which outweighs the rigors of section 37, my lord. Page paragraph 16, page 40 is the lordship's finding, my lord. So I'm also, my lord, seeing that perhaps better. Yes, my lord. If lordship can kindly consider my prayer at this stage, my lord.
Yes, why he was arrested?
My lord, arrested on my lord, 12/3/2023, my lord. 12/3.
But nothing was found from his.
Nothing was found, but my lord, lordship may kindly see, my lord, that page number 32, my lord.
32.
Because my lord, page number 32 of the bail application.
Yes.
The charge sheet, please.
Charge sheet, my lord, this is charge sheet, my lord, that during analysis of CDR, following facts are found, my lord. On 8/2/2023 to 9/3/2023, the location of mobile phone number so and so, Badrul Islam was found to be at Bihar, Pepar Bilas, Sampai district, Mizoram. And on the same day, that is on 9/3/2023, the location of mobile phone number of Aftabuddin, my lord, and Abdul Qadir, my lord, from whose possession the narcotic drugs were recovered, my lord. They were in constant touch with each other, my lord. Admittedly, my lord, nothing was found, my lord, but my lord, as per the charge sheet, my lord, the contraband supplied by him, my lord.
No,
And
but
lordship has already granted bail to 3 accused persons, my lord, that I have also
okay,
seen.
heard Mr. M.A. Chaudhary, learned
My
counsel.
objection may be recorded because only by the in long incarceration, my lord.
Heard Mr. M.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. R.J. Burma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Badrul Islam, who has been detained behind the bars since 12/3, 11/3.
It is, my lord, it is only the registry got confused, so 11/3, actually 12/3, my lord. Page 23 is date of arrest is there.
Since 12/3/2023, within bracket for more than 2 years, in connection with special NDPS case number 21/2023, pending before the Court of Learned Special Judge Karimganj, arising out of Bajari Chera PS case number 63/2023, under section 21(3)/25/29 of the NDPS Act. Gist of accusation, quote from page 36, para 3. Para 3, para 4. Para 5, para 6. Learned counsel, Mr. M.A. Ahmed. Sorry, M.A. Chaudhary, learned counsel for the petitioner, has submitted that the petitioner was not an occupant of the vehicle from which the contraband was recovered. Nothing was seized from the possession of the present petitioner. And he has been arrested in this case only on the basis of suspicion. Learned counsel for the petitioner has also submitted that in the meanwhile, also submitted that the petitioner has been detained behind the bars since 10/3/2023 and till date, out of 9 listed witnesses, not even a single prosecution witness has been examined. He also submits that in the meanwhile, 3 of the co-accused have already been granted bail by this court by order dated 17/2/2025 in bail application number 294/2020. He submits that the petitioner is also entitled to get bail on the ground of prolonged incarceration. Code para 8. Code para 9. Learned additional public prosecutor has also submitted that the petitioner was in constant touch with the other co-accused persons as appears from the CDR analysis. And he is the source from where the contraband was procured. Stop. Then 10, 11, 12, 13. 14, 15, 16. 17 in para 17 instead of 1 year, 11 months, more than 2 years. 18, 19. 1 lakh with 2 sureties of like.
Deep your question. Deep your question.
No, the changes could be laga supply. Next item.
26, my lord, case diary of PC, my lord. I has paid for some time to produce the case diary.
It is 41 days, Lordship.
What is the
offense is
offense?
under 406 and 420. She is a lady, Lordship, widow, having a minor daughter.
She took money, my lord, from the complainant, my lord, in order to, my lord, provide some job. My lord. That is the allegation.
But 41 days is.
41
Next
days.
week, my lord, will produce it from dispute police station, my lord.
Okay, let the additional PP also get one chance. Short date.
What's a short date?
Heard Mr. T. Chakraborty, learned counsel for the petitioner. Also heard Mr. R.J. Burwal, and the additional public prosecutor, who prays for allowing some more time to the petition, for producing the case diary. That's all. The prayer is allowed. So let this case be listed again on
21, my lord.
21.
Much of it.
Item 64 supplementary.
Please, your lordship, my lord. On the last 3 occasions, the NCB was granted time to secure some instruction regarding if there is any matter to show that the accused is involved in any other case. Apart from being heard the matter, my lord.
Where is NCB?
They don't come because they know there is no material, my lord. Because they cannot improvise the case. What is already written is written, my lord.
That may be one reason. Other reasons, shortage of manpower.
I don't know that, my lord. But when the case is called, they should be here by at least somebody they should send, my lord. Last time one lady appeared.
What is to be done?
Because it's still in the appearance stage and I am behind the bar for the last 1.5 years, my lord.
NCB, you are always late. When accused escapes, you reach the place of occurrence.
Lordship, I am another court lordship.
What is your prayer?
Lordship, kindly pass over the matter for time being. My senior will appear, lordship.
Okay.
At what time? Can you fix the time?
Fix at 2, lordship.
After lunch.
No issue, but please ensure that he comes. That will do, that's much obliged.
Lordship, today 60,
60 at
61 Lordship.
61, also NCB case.
Lordship. May I please the Lordship, my lord? Lordship, we are filing objection today, Lordship.
61 to do.
Lordship, in earlier occasion, they have stated that they will file the objection, Lordship, but they did not file. Lordship, actually, in this case, the 3 co-accused persons has already released on bail, Lordship. In similar footing, Lordship. Lordship, kindly peruse the judgment. That's why your Lordship called the scanned copy of the another case, Lordship.
When will you file the objection?
They have not Today, filed Lordship. the objection.
Today you'll be filing. Let
Lordship.
them file. They will be filing objection today.
Lordship, we did not get copy, Lordship.
No, they will be filing. They have not yet filed.
Lordship, more than 2 years, 5 months, Lordship, behind the bar. I am appealing on behalf of Mr. Anand Chaudhary, Lordship. Actually, he is in, he went for some medical test. He will come.
What is the quantity of contraband?
Quantity of contraband, Lordship, 517 kg from the possession of another accused person.
517 kgs of
Cannabis, Lordship, from the another truck, Lordship, and we are.
We'll fix it on Monday.
Monday.
Let them file objection.
Lordship, fix it 19, Lordship.
Okay.
Lordship,
Okay.
Lordship, kindly on Monday, Lordship. Lordship,
Okay, 19.
fixed on 19, Lordship.
Third, Miss, what is your name?
Okay, they on behalf of Mr. Anand
Okay,
Chaudhary,
the
Lordship.
learned counsel for the petitioner. Also, heard Miss
And Kakoti, Lordship.
N. Kakoti, learned counsel for NCB, who submits that the NCB will be filing written objection during the course of the day, and she prays for listing this matter on some other day. Considering the
Lordship,
submissions,
fixed 19, Lordship. Lordship, next Monday, Lordship.
considering the submissions made by learned counsel, the president will let this matter be listed again on 19th of
March, Lordship. Highly obliged, Lordship.
My lord, 27 and 28, my lord, uploaded CD was false, my lord. Earlier we received the case diary, my lord, but today, my lord, we have not received the case diary.
Lordship,
Intermotor, sir.
we have filed 2 IA also, interlocutory applications, Lordship. One is tagged, IA 127 of 2025 is tagged, Lordship. But another IA on 58 of 2025 is
you are
not.
for the victim
I am for the informant, Lordship.
or cancellation.
For cancellations of the anticipated bail they are enjoying, Lordship.
Let the case diary come.
Lordship. That
Heard-
IA be tagged, Lordship.
Heard Mr. U. Dutta, learned counsel for the petitioner. Also heard Mr. R.J. Borwa, learned additional public prosecutor, who submits that some more time may be granted for producing the case diary. Prayer is allowed. How much?
27 months.
Let the-
We
prayer
are
is
an
allowed.
interim, man.
Also, Mr. What is your name?
N.M. Ajarboya.
N.A. Majar Bhuya, learned counsel for the informant, submits that in AB case number 2097, in both these anticipatory bail applications, the informant has filed interlocutory applications praying for cancellation or vacation of the interim bail granted to the
Pleading petition.
petitioner. However, in AB case number 3100/2024, the interlocutory application has not been tagged with the record. Not 31. 3097. 3097/2024.
Lordship, 3097 is tagged, Lordship. IA in
31.
Lordship, 3100.
Okay, 3100, it is not tagged with the case record. Registry is directed to list the interlocutory application filed by the informant with the records of this case on the next date of hearing. List this matter again on which date, Mr. Burwa? 27th. Let this matter be listed on 27/3. Interim order shall continue till next day.
One case diary not received, my lord.
You are on interim.
There is, we are placing the bail for petition number 2, my lord. But in the last order, it is mentioned for both the petitioners.
Why petitioner number 1?
Kindly pay us for order dated 4 to 25.
Okay, what happened to petitioner number 1?
With the pendency of this case.
He has been arrested.
Subsequently, he got bail.
Okay.
So we are placing for number 2.
One arrested.
Heard Mr.
Chakraborty.
C. Chakraborty, learned counsel for the petitioner. Also heard Mr. R.J. Burua, learned additional public prosecutor, who has prayed for some more time for producing the case diary. The prayer is allowed. Stop. Mr. C. Chakraborty, learned counsel for the petitioner. Petitioners has submitted that during the pendency of this anticipatory bail application, the petitioner number 1 has been arrested. However, it is inadvertently in the order dated 24/2/2025. It has been stated that both the petitioners were allowed to go on anticipatory bail. He submits that said order needs to be corrected. So, in view of the fact that the petitioner number 1 has already been arrested before issuance of interim bail order in his favor on 24/2/2025. The interim bail order in respect of the said petitioner, that is, namely Jahirul Islam, has become infructuous. However, in respect of the other petitioner, namely Afzal Hussain, the interim order shall continue till next date.
Next day, my lord, 2nd of April, my lord.
Let this matter be listed on 2nd of April.
May it please your lordship. Here, my lord, I was an interim, my lord.
Case diary received.
I appeared, my lord. I purported, and my statement has also been recorded, my lord. The investigating unit.
Heard Mr. S.M. Statement recorded.
My lord, statement recorded.
Heard Mr. S.M. Abdullah P. learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail by order dated.
One important thing, my lord, she was sent for medical examination, refused. She refused medical examination.
Victim.
Victim.
Last name. By order dated 17/2/2025 by this court, and in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. Stop. On the other hand, an additional public prosecutor has produced the case diary of Lahorigarh PS case number 20/2025, and has submitted that the victim girl was produced before was taken for her medical examination. However, she has refused to undergo medical examination. Stop. On the other hand, the petitioner has appeared before the investigating officer, and his statement under section 180 of BNSS has already been recorded. So, in view of submissions made by learned counsel for the parties, as well as in view of the fact that the petitioner has complied with the orders of this court and has cooperated in the investigation, the interim anticipatory bail granted to the petitioner by order dated 17/2/2025 is hereby made absolute, with the conditions attached to the said order remaining intact. Send back the case diary. This anticipatory bail application is accordingly disposed of.
Madam, again, we will appear within 10 days, madam, the first order. There was a within 10 days or like that.
You have not appeared.
No, we appeared, madam. I will again appear, madam.
Why?
But the conditions are same, lordship saying.
No, that condition is not there.
Oh, lordship. Then I'm sorry, madam.
Condition number 1 is cooperate in investigation. Number 2, you will not directly or indirectly induce.
Lordship, I'm sorry, I'm obliged, madam. I'm deeply obliged.
Yes, on the case that is.
Lordship, petitioner after granting of a PM relief, he appeared before the IO and his statement has been recorded. Lordship.
Heard Mr. D. Das, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional prosecutor. Learned counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail by order dated 19/2/2025. And in pursuant to the directions of this court, he has appeared before the investigating officer and has cooperated in the investigation. Stop. On the other hand, learned additional public prosecutor has produced the case diary of dispute PS case number 67/2025 and has submitted that the petitioner has appeared before the investigating officer and his statement under section 180 of BNSS has already been recorded. In view of the fact that the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim anticipatory bail granted to him by order dated 19/2/2025 by this court is hereby made absolute, with the conditions attached to the said order remaining intact. Send back the case diary. This bail application is accordingly disposed of.
I'm obliged.
Item 27. May I please, my lord, one additional affidavit is submitted, my lord, in this case.
Additional affidavit is. Yes, what is this?
My lord, bail rejection order from my lord, additional affidavit page 28, my lord. And my lord, perhaps my lord may be relevant, my lord, page 29. Last paragraph, my lord, from the submission of the learned PP, my lord.
Yes.
The learned public prosecutor submitted that the informant has sustained head injury. He also submitted that the case is at the investigation stage. I have scrutinized the materials on case diary and found that the investigating officer has recorded the statement of several witnesses. Further, the investigating officer has also seized one stone approximately of 4 grams in weight. The investigating officer on his note dated 21/2/2025 mentioned that the accused petitioner is not cooperating with the investigating agency. I have scrutinized materials on the case diary and found that on 22/2/2025, the present accused petitioner who was granted interim pre-arrest bail on 18/2/2025 appeared before the investigating officer. The medical examination report of the alleged victim shows that on the right parietal region, laceration was detected, which is simple and caused by blunt object. I have considered materials on record, the allegation against the present accused petitioner, and the nature of the offense. This court is with the opinion that the privilege of arrest bail may not be offense. Nothing.
You have cooperated.
Cooperated, my lord.
You were granted interim bail.
Yes, my lord. And appeared, my lord, statement is also recorded, my lord.
And there is no material to show that he hurled the stone. Stone was from the
Crowd.
crowd.
But in page 29, Lordship, it is stated that the FIR further reflects that another unlawful assembly was led by the present petitioner, Lordship, who abated public for taking law in their hands. Abatement is there, Lord.
No, but they have filed some photographs showing that the petitioner was with the superintendent of police, trying to control the mob. Is it your case?
Yes, my lord.
Heard Mr. A.M. Bodmere. Is there?
It is not motion, Lord.
A.M. Bodmere. Learned. Is there would be required or we can dispose it out?
It will be better, Lordship, to look into it, Lordship, because it has been earlier rejected, Lord.
Okay. But rejection is not, it is not very much reasoned rejection.
Yes, my lord. And allegation is also not there, my lord. He was with them, and my lord, I have given photograph, my lord. He was supporting my lord, police, my
Okay,
lord.
still let us call for the case.
But head injury is there, Lordship, that is my lord.
Mr. A.M. Bodmere, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner seeking, who is apprehending his arrest in connection with Hailakandi PS case number 25/2025 under section 54/127/125B. ये यहाँ से page, first page. The gist of accusation in this case is that where is the FIR?
Well, FIR, my lord, annexure 1, my lord, it is already typed, my lord, page 14 is the relevant portion.
That one, Akshay Kumar Das had lodged an FIR. One Akshay Kumar Das had lodged an FIR before the officer in charge of Hailakandi police station on 6th February 2025, inter alia alleging that one road traffic accident occurred at about 12:10 p.m. and police was called. However, police arrived at the place of occurrence at about 1:40 p.m. and there was a huge gathering of local public who blocked the national highway and wrongfully restrained the vehicles plying on the national highway and damaged the vehicles also. The police team was also prevented from doing their duty, and one of the police personnel also sustained injuries due to stone pelting by the agitated public. Stop. It is alleged in the FIR that the present petitioner and one Johiruddin Laskar instigated the mob to commit the alleged offences. Learned counsel for the petitioner has submitted that the petitioner is a, who are you? Who are you?
My lord, he is my lord, panchayat representative, Jila Parishad of the locality, my lord, and
Member.
he went there to help the police, my lord.
He's a member of local Jila Parishad and he reached the place of occurrence
To control the public.
to help the police in controlling the public. Stop. He further submits that the co-accused Johiruddin Laskar has also already been granted bail by the Court of Learned Additional Session Judge. Additional Session Judge Hailakandi. Stop. It is also submitted that the petitioner was also granted interim bail by the Court of Session Judge. And he had cooperated with the police during his when he was on interim bail. However, by order dated 3/3/2025 past miss case, criminal miss case number 42/2025. The interim bail of the petitioner was vacated in spite of the fact that he had cooperated in the investigation. So, learned counsel for the petitioner has submitted that the petitioner is ready to cooperate in the investigation. And as he had earlier cooperated in investigation, his custodial interrogation may not be necessary in this case. On the other hand, learned additional public prosecutor has submitted that since in this case, injury to police personnel has been caused due to mob violence, case diary may be required. Stop. Call for the case diary. Fixing
2nd April.
2nd April for case diary. However, in the meanwhile, as one of the co-accused against whom similar accusations were made in the FIR has already been granted bail, and it also appears that there is no allegation against the present petitioner that he misused his liberty when he was on interim bail granted by the learned session judge Hailakandi, the petitioner is directed to appear before the investigating officer of Hailakandi PS case number.
Hailakandi PS case number, my lord, 25 of
25 of
2025.
2025 within a period of 7 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with the above noted case, he shall be allowed to go on bail of rupees 30,000, interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1. List on 1st of April.
Diploma.
None has appeared. List this matter in the next week on a date to be fixed by registrar.
Please, Your Lordship. I'm appearing for 36, Lordship. Notice was issued to respondent number 2 and 3, Lordship. A conviction under POCSO 4, Lordship.
POCSO is there. Two and three are
Victims, sir.
duly served.
Sir,
Will appoint an amicus. Heard, Miss in appeal. In main appeal, heard Mr. M.I. Hussain. Item number 36
36, I'm appearing for 36, Lordship.
and 37 is there.
37 POCSO is not there, 365.
Okay. Heard Mr. M.I. Hussain, learned counsel for the appellant. Also heard Mr. R.J. Purva, learned additional public prosecutor. This on perusal of the office note dated 6/3/2025, it appears that notice to the respondent number 2 and 3 are duly served. Stop. However, none has appeared for respondent number 2 and 3. This court intends to appoint an amicus curiae to defend the cause of respondent number 3. Ms. Saikya, Debashri Saikya. You be the amicus curiae.
Lordship.
This court intends to appoint Ms. D. Saikya, Debashri Saikya, learned counsel whose name is there in the panel of amicus curiae prepared by the registry of this court, is hereby appointed as an amicus curiae to defend the cause of respondent number 2 and 3 in this appeal. The petitioner, the appellant shall furnish a memo of appeal, copy of memo of appeal with annexures to the learned amicus curiae for respondent number 2 and 3. The paper book will be necessary.
Everything is typed in English. Typed in English.
And you have annexed it in with the memo of appeal. How the amicus will get.
Paper book is necessary if possible.
Since the records of this, since the trial court record have been received, the registry is directed to prepare paper book and list this matter again after preparation of the paper book.
My lord, for IA, paper book may not be necessary. Lordship, therefore, matter may be taken within this month, Lordship. I will serve the copy today.
In IA also, same order. This interlocute, in IA also heard Mr. M.I. Hussain, AK order. Notice is served on respondent number 2 and 3. Since Ms. Deba AK order.
Lordship, the date in this
You
month.
furnish the copy of the interlocutory application.
Lordship, today itself I will furnish.
Release this interlocutory application for consideration on when?
A date within this month, Lordship. Because there is
On 28,
220, Lordship.
28.
Before 20,
Before
before 28, any date, before 28.
Suggested date,
25th.
25th, list on 25th. Item number
37, my lord, the IA has already been allowed, my lord. We are on bail.
37 also, same order.
Other than
Here
POCSO,
the amicus is not necessary.
Not necessary because POCSO is not there, my lord. Please,
Heard
please.
Mr. S. Nawaz, learned counsel for the appellant. Also heard Mr. K. Das, learned. Agor case to additional public prosecutor का नाम दे देना. Mr. K. Das. K. Das, learned additional public prosecutor. This This case is. How much? What is the item number?
Item number 37.
This case is tagged with criminal appeal number 387/2024, in which a direction has been issued to prepare the paper book. Let this case be listed after preparation of paper book along with the criminal appeal number 378/2024.
I'm deeply obliged.
Deeply obliged, Lordship.
May I please, Your Lordship? So as per official dated 11/3/2025, Lordship, service report in respect of respondent is awaited, Lordship.
Milord, for respondent number 2, we
You
have
are
received,
appearing.
we have received a notice, Milord, from this court. Milord, the respondent number 2's name as Patnaik is not in the company right now. And if your lordship will permit, then the current principal human resource officer, on behalf of who, that he can take the steps in the proceeding.
Who is respondent number 2?
They already appear, Lordship.
The company, on behalf of the company, respondent number 2 S Patnaik has filed the FIR. And Milord can look into page 14.
Yes. Some bit Patnaik, no?
1/4.
In what capacity FIR was lodged?
Milord, he is principal human resource officer of Bharti Airtel. In the capacity, he has filed that FIR.
Where is the FIR?
Page 14, 1/4.
Yes, what is the solution?
They are, represented on behalf of the Sambiban. They are already appear, Lordship. Notice may not be required, Lordship. They can appear on behalf of company, Lordship.
Heard Mr. B. Islam, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. What is your name?
S. Sharma.
Mr. S. Sharma has appeared for respondent number 2 and has submitted that the respondent number 2 had lodged the FIR in question in capacity of public and health relation or
Principal human resource officer.
principal human resource
Officer.
officer of Bharti Airtel Limited.
My lord.
However, after lodging of the, now you have been transferred or
He has been transferred 3 years ago, my lord.
however,
Now the present
the
one,
first informant has been transferred 3 years ago, and now the present principal human resource officer is Mr.
Manaspratim Borami.
Manashpatim Borali, and he may be allowed to represent the first informant in this case. The petitioner does not, learned counsel for the petitioner does not object to the said prayer, hence the same is allowed.
My lord.
Let this case be listed for admission hearing.
Date may be fixed, Lordship.
No. After 2 weeks on a date to be fixed by registry.
Only date may be fixed, otherwise there's the interim PR, Lordship.
No, date is difficult.
All right, my lord.
Yes.
Lordship, this is an application under 6583, Lordship. praying for quashing of the criminal proceeding initiated.
Why it has come up for orders today?
Lordship, we have heard that my learned friend has appeared for rescuing.
You have
Informant.
heard, Mr. This is item number 30. Heard Mr. R. Islam, learned counsel for the petitioner. Also Mr. K. Das, learned additional public prosecutor, as well as Mr. M.Z. Shah, appearing for respondent number 2. Let this case be listed for admission hearing after 2 weeks on a date to be fixed by the
Lordship, next date fixed on 8th of April, Lordship. Kindly fix a date fixed prior.
in the first week of April on a date to be fixed.
A
by-
date may kindly be fixed first.
No,
Then your Lordship will fix a date after 2 weeks. Because it doesn't come, Lordship.
okay, after 2 weeks on a date to be fixed by registry. Fixing a date by court
Lo-
is difficult.
Your Lordship will kindly.
After 2 weeks on a date to be fixed by registry.
Obliged.
Please, your lordship. Lordship, the impugned charge has been filed against the accused person under section 313, 323, and 506 of IPC, your lordship. And where is the 313 under
Who is the- Why it has come up for orders column today?
37, page number 35.
No, why it has come up for orders?
And sir, lordship, the informant is the major lady. Her age is 26 years. And where is the mention the 313 of the IPC, your lordship?
But else-
Miscarriage without woman consent.
Stop. Answer my query. Have you taken steps for issuance of notice?
Yes.
The notice has returned back with postal remarks that insufficient address. You have not given proper address. You have to take fresh steps.
Lordship, LCR received, your lordship, today. So
LCR has,
interim stay may be allowed only, your lordship.
LCR has been received, but
Yes.
the notice has not been served.
Interim stay only, your lordship, because your lordship, the woman, she is the 26 years old, your lordship, and where is the mention in under section 313, causing miscarriage without woman's consent. Whoever commits the offense defined in the last proceedings sections without the consent of the woman, whether the woman is a quick with child or not, shall be punished with imprisonment for life. Your lordship, how can come to forcefully, your lordship, or without the consent? Because your lordship, she is the 26 years old, your lordship. They are not a married couple, and she also mentioned in this FIR also they have a relationship, or lordship, but she is the woman who is the 26 years old, and without her consent, doctor also no right to provided any medicine, your lordship.
So on a major woman, no offense under 313 may be committed.
Lordship, they are not a married couple. They are have no any compulsory for resided in the same residence, your lordship. Then how can come to without consent, but with consent?
We will ask the lady when she appears before this court.
Lordship, there have also
let her
no
appear.
witnesses where she has mentioned the 506 and 323 also, your lordship.
Miss-
These sections are served as in frame, your
Heard
lordship.
Miss A may be
Of her
Learned counsel for the petitioner, also heard Mr. K. Das, learned additional public prosecutor. On perusal of the office note dated 11/3/2025, it appears that the scanned copy of the trial court record have been received. However, the notice issued to respondent number 2 has returned with postal endorsement within inverted comma insufficient address, RTS. The petitioner is therefore directed to take fresh steps upon respondent number 2 within 7 days from the date of this order, giving proper address. You take steps to which police station?
Omen Police Station,
Nunmati Police Station.
not Nunmati, Your Lordship, Omen
No,
Police Station.
no, where the resident she resides. No, Nunmati Police Station. The petitioner shall take steps for issuance of notice upon the respondent number 2 through the registry to be served on the respondent number 2 by the officer in charge of Nunmati Police Station within Nunmati Police Station. After service of the notice on the respondent, the officer in charge shall furnish a service report to this court through the office of the learned public prosecutor before the next date fixed. Let this case be listed again on when? 24 March.
Lordship, before two months more, we have issued a notice to the respondent number 2, Your Lordship. And at first, we have lodged an FIR against the informant, Your Lordship. And our FIR is, Your Lordship.
You go through what I have said. The notice has returned without service. Therefore, you have to take fresh steps. List accordingly on 24th of March. 24th of March.
And Lordship, interim stay may be allowed, Your Lordship.
After service of notice only.
Already LCR received, Your Lordship. On the last occasion, this honorable court already mentioned it. After received the LCR, then interim stay may be allowed, Your Lordship.
Should I pass order for rejection of the interim order, or should you wait till 24th? Yes, next item.
I've taken steps as part of the last order. Minor service return letter now.
You take fresh steps. Heard Mr. L. Gogoi, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. The office note. You have to take information, Mr. Das. Notice has been sent through OC. You take information. Office note dated. Office note is not clear. Office note dated 4/3/2025 shows that though the petitioner has taken steps for issuance of notice through the officer in charge of concerned police station, however, the report is still awaited. Learned public prosecutor is requested to let this court know regarding the fate of the notice issued to respondent number 2 after getting necessary instructions from the officer in charge of jurisdictional police station on the next date fix. List this matter again on 27th of March.
May I pray for a correction of an order, my lord, of 10/3/25, my lord, passed by your lordship, my lord. Lordship is not available in next week, my lord. We have filed an IA, my lord, for correction. There should be 2020.
No, you want listing, unlisted.
No, unlisted, my lord. We have filed an IA, my lord. Today
So
itself.
that
we have-
I has to be listed.
Yes, my lord. Can be the last item, my lord.
Okay.
Only that is there, my lord. Deeply obliged. Obliged.
Lordship, we have filed this IA for suspension of sentence. Lordship, today is the first occasion, Lordship. Notice may be issued.
Heard Mr. A.T. Sarkar, learned counsel for the petitioner. No, learned counsel for the applicant. This application under section 430 of BNSS has been filed by the applicant / appellant praying for suspension of sentence which has been imposed on the applicant by the judgment and order dated 23/12/2024, passed by learned additional sessions Judge FTC Rongia in sessions case number 9/2018, whereby the applicant was convicted under section 376 of the Indian Penal Code and was sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of ₹5,000, and in default of payment of fine to undergo simple imprisonment for 1 month. Issue notice to the respondents. The state will be filing objection.
Yes, Madhu, we have to let the LCR come, Madhu.
Okay. The petitioner shall take steps for issuance of notice upon respond. The applicant shall take steps for issuance of notice upon responding by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 25th of April, list accordingly.
May I please, Your Lordship? Lordship, in this matter, as per office note dated 22/25, the service is also complete, Your Lordship. And LCR also called for.
Heard Mr. E. Ahmed, learned counsel for the.
R.A. Majumdar, Your Lordship.
Heard Mr. R.A. Majumdar, learned counsel for the petitioner. On perusal of the office note dated 11/3/2025, it appears that the scanned copy of the records has not yet been received. Neither service report is of the notice issued to respondent number 2 has been received. Stop. Await further. Issue reminder for the scanned copy. List this matter after 2 weeks.
Interim may be continued, Your Lordship.
The interim order shall continue till next day.
Oblige.
The service about the respondent number 2 is waited. After last week.
Heard Mr. S. Islam, learned counsel for the petitioner. The service report in respect of respondent number 2 is awaited. Await further, lest this matter be listed after 2.
Last week of this.
In the last week of this month. In the last week of month of March 2025.
Oblige.
May I please, as a lordship? My lord, we have filed an interlocutory application, my lord, for the purpose of modification of an interim stay, my lord, which has been granted ex parte. My lord, the maintenance which has been awarded to us, my lord, had been stayed. Partly, my lord. My lord, may be pleased to find the order.
You are,
And I,
you are
188 of
you are
2020.
respondent.
My lord, yes, my lord, in this petition, criminal revision petition 307, I am the respondent wife, my lord.
Okay.
My lord, by of an order dated 6/9/2024. My lord, the maintenance which has been directed to be paid 20,000 for me had been stayed by this honorable court, my lord. And 12,000 had been stayed and 8,000 for my, my lord, only child. That has not been interfered with by this honorable court, my lord. My lord, the ground which they have taken in the criminal revision petition, my lord, that the assets and liabilities was not disclosed. And while we moved the 125 application, my lord, we did not disclose the another proceeding of the domestic violence, my lord, which was I did file as a wife.
In fact, my lord, if we peruse the order which they have impugned, it reflects the, my lord, that the both counts are not correct, my lord. Therefore, my lord, I beg to draw my lordship's attention, my lord, to the order passed by the learned trial court below, my lord. That may be, that my lord may be pleased to find at page 62, my lord.
We are taking revision petition.
Yes, yes, my lord, in the criminal revision petition.
Lordship,
Why? Yes.
before submitting my learned friend, learned trial court already issued warrant against the petitioner lordship due to non-payment of arrear amount lordship, which is misinterpreted, and for the stay of the said order, already I have filed an IA, which is yet to be listed lordship, and I have also urgency lordship. If next date is fixed on 19 March lordship, this 19 March. If the main case is disposed of before 19 and last order, which is
No, when LCR is there, na? This main case can be heard.
Main case, my lord, if the main petition is heard, everything will be resolved.
When?
18 or 19.
But as my learned friend has some in, they filed the IA, which is not on record, my lord. So I do not want that any prejudice should also cause to him, my lord. Before 19, my lord can fix any date, my lord. Because, my lord, I am now.
On 18.
My lord. Because I am the wife, my lord, I do not have any other source, my lord, except the maintenance which has been granted, my lord.
Main criminal revision petition applicable. Heard Mr. S.H. Rahman, learned counsel for the petitioner. Also heard Mr.
A.R. Bhuya,
A.R. Bhuya, learned counsel for the respondent. Learned counsel for the respondent has submitted that the respondent has filed an interlocutory application for vacation of the stay, interim stay in respect of the maintenance award of rupees 12,000 awarded to the respondent.
Number 2, my lord, in the main.
Respondent number 2. Stop. On this, learned counsel for the petitioner submits that the petitioner has also filed an interlocutory application as the trial court has issued non-bailable.
Distance warrant had been issued.
Distress warrant has issued a distress warrant for realization of arrear amount due from the petitioner. Stop. Learned counsel for both the parties agreed that as the scanned copy of the LCR is available, instead of hearing the interlocutory applications filed by the petitioners as well as the respondent, the criminal revision petition may be finally heard and disposed of.
What?
Stop.
18th of.
After hearing learned counsel. Stop. Considering the submissions made by learned counsel for the parties, this court is also of the opinion that, considering the nature of case involved, it would be better to dispose of the main criminal revision petition finally, that is criminal revision petition number 307/2024. Accordingly, let this matter be listed on 18th of March for final hearing of the criminal petition.
Lordship, interim order may continue and my IA may come up. I have got filing number, Lordship.
No, on that day.
Main case will be heard, but
you may mention before the court. After, let it be registered.
Okay.
Let it be registered and you make a mention.
Interim order may continue.
The interim order shall continue till next day.
Obliged.
Obliged. Highly obliged.
Next level. My lord, that is a case in a my lord joint family, my lord. Among the even my lord, the informant has made his my lord own father and brother accused in this case, my lord. This honorable court, my lord, granted a arrest bail to all the petitioners except my lord petition number 1, as there is my lord no incriminating allegations against them. Page 29.
But report, service report
Yes,
and
this is the my lord.
records of the trial court have to come. Heard Mr. A. M. Bordmia, learned counsel for the petitioner. On perusal of the office note dated 11/3/2025, it appears that neither the trial court record nor the report nor the service report in respect of the notices issued to the respondent number 2 has been received. Await for the service report and issue reminder for trial court record. Let this case be listed again.
And any date may be required.
Again on 4th of April.
Diploma.
This is application for condonation of delay of 11 days in presenting the appeal.
Criminal appeal. Heard Mr. U. Datta, learned counsel for the petitioner. This application under Section 5 of the Limitation Act has been filed by the applicant, praying for condonation of delay of 11 days in preferring the connected appeal against the judgment and order dated 7/12/2024, passed by learned Special Judge Poxo in Special Poxo case number 27/28. Issue notice to the respondents. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued. As regards respondent number 2 is concerned, the applicant shall take steps for issuance of notice upon the respondent number 2 in pursuant to the notification which is prevailing in that regard within 3 days from the date of this order, returnable on 28th of April 2020.
Published.
My lord, in this matter also service report is awaited. My lord. But otherwise, my lord, another connected matter, my lord, 64, my lord, where my lord, the same respondent have filed.
I am the
My lord.
petitioner in 64.
Actually, both the cases are my lord, case and cross cases, my lord, before your lordship.
But in
Between the same parties,
Same
you can
party.
appear.
Lordship, in this ticket, I have no instruction, Lordship.
Same,
Take instruction.
you
and
take
another-
instruction.
Lordship.
Heard Miss When
Next week, my lord, after
2 weeks, Lord.
in 64, heard
After 2 weeks, Lord.
item number 11. Mr. Bordmia, you are petitioner in which matter?
the first one, my lord. 63.
63.
Yes, my lord.
Heard Mr. in 63, heard Mr. A. M. Bordmia, learned counsel for the petitioner. It appears also heard Mr. R. J. Borua, learned.
AMS Majumdar.
You are appearing?
No, Lordship. In item 34, 64.
Also heard Mr. A. M. S. Majumdar, who is appearing for the
I am the petitioner in the item 64, Lord.
petitioner of criminal petition number 734/2024. Since the petitioner of the said criminal petition is the respondent in this case, Mr. A.M.S. Majumdar, seeks some time from the court to take proper instructions from the respondent regarding his engagement in this case. The prayer is allowed. List this matter after a week on a date to be fixed by registry.
After 2 weeks, Lordship.
After 2 weeks on a date to be fixed by registry. In item number 64, heard Mr. A.M.S. Majumdar, learned counsel for the petitioner, also heard Mr. A.M. Borgoya, learned counsel for the respondent, as well as Mr. R.J. Borua, learned additional public prosecutor. LCR has come. Trial court record. Same trial court record.
Yep.
The scan copy of the records of the trial court has been received. Hence, let this matter be listed for admission hearing on after 2 weeks on a date to be fixed by the registry. Let this matter be tagged with the remain tagged with the criminal petition number 182/2025.
Kindly, my lord, any date may be.
Fixing date is difficult. Item number?
My lord. Deep look.
May I please your lord.
20. Yes.
FR lordship will find on page 16, lordship.
Case diary has, is there.
Segment.
48 days, lordship.
Is the allegation?
Lordship, can you go through also the type copy also, lordship, is it page 9? Page 9 is there.
Yes. Yes, please read. What is the accusation?
Accusation, lordship, that I have uploaded a photo, lordship, which have had a photo shoot, lordship, from another person. There was an agreement for paying money and all. Therefore, my part is that, lordship, that some photos were uploaded in a fake account of Instagram, and thereafter, lordship, some money has been claimed as a lordship for that. It's a accusation against me. May I read the FI, lordship?
Now, what is your ground? 48 days.
48 days, lordship.
Anything else? Anything else?
Regarding that part only, so the detention and investigation might have completed, lordship, in my part, lordship.
Yes.
My lord, her 183 statement recorded, my lord. Whatever, my lord, she agreed to do my lord photo shoot for some advertisement purposes, my lord. Then, my lord, this photo shoot was taken by my lord, one Abhishek Kolita, my lord. He shoot the photographs, my lord. It is in the year 2023. Now, in the year 2024, my lord, one person, my lord, that is the petitioner, my lord. He, my lord, viral some photographs of the, my lord, victim girl, my lord, on Instagram.
Photos are obscene photos.
My lord.
Obscene photos.
Option, my lord, as per her 183 statement, my lord, she said it is half nude photograph, my lord. For what purpose?
No, whether further detention is required.
My lord, the main accused is yet to be arrested, my lord. This is my humble submission, my lord. Otherwise, my lord, this person has been arrested.
Heard Mr. S. Mani, learned counsel for the petitioner. Also, Mr. R.J. Burua, then an additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Rohan Ghosh, who has been detained behind the bars since 25/1/2025 in connection with Chandmari case number 16/2025 under section 351 within bracket 2/77/79/316 within bracket 2/3 within bracket 5 of BNS read with section 66 within bracket capital E/67 of the Information Technology Act. The gist of accusation in this case is that on 23/1/2025, the victim girl has lodged an FIR before the officer in charge of Chandmari police station, inter alia, alleging that the petitioner has uploaded the semi-nude photographs of the victim girl in the social media within bracket Instagram without her consent. And thereafter, the petitioner is blackmailing the victim girl for deleting the said photographs. Stuff. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars since last 48 days, and he is not the main accused. No. Since last 48 days, and considering the period of detention, he may be allowed to go on bail. On the other hand, an additional public prosecutor has opposed the grant of bail on the ground that one of the co-accused is still at large, and there are sufficient incriminating material against the present petitioner in the case diary. I have considered the submissions made by learned counsel for both the sides and have gone through the case diary of Chandmari PS case number 16/2025. Considering the progress made in the investigation as well as period of detention already undergone by the petitioner, this court is of view that the further custodial detention of the petitioner may not be necessary if he cooperates in the investigation. So hence, the appropriate petitioner is allowed to go on bail of 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro, with following conditions. Condition number 1 and 2. Send back the case diary. This bail application is according with his consent.
Much obliged, Your Lordship. Much.
Yes.
Please, Your Lordship, I brought the case files and I have marked the relevant paragraphs also. I have phlegmaed it regarding the statements made by the accused and Lordship.
No, you take it first. You have to read it. What is your case?
My lord, the case was that, my lord, that nothing was recovered from my position, nothing was given to me by anybody. I was just coming behind that cloud, and accordingly, it is suspected that I was the.
Their case is that you were escorting the vehicle.
Yes, escorting and following, they have used the word, I was following that truck, so to take delivery or something like that. But nothing was delivered to me, nothing was found from my position. And I have been just made an accused because they said that I was also earlier involved, I took delivery. So your lordship wanted to know what is the material to that effect.
Yes.
So he was given time for that to show that whether any case
Is
has
there
been
any
raised there,
material?
whether there is any
Lordship,
case or not. Just by saying will not be enough.
Statements are there, Lordship, where he has confessed that he has received that parcel 15 days ago. And also, Lordship, the CDR is there where he has been regular contact with the supplier of the ganja, who is Umar Kazi. There it is there, or and so Lordship, he has submitted, he has deposited 50,000 rupees in the bank account of Umar Kazi, who is the supplier, and the deposit slip has been found in his pocket. That is also there, Lordship. That I have marked in this case file. Lordship can peruse that case file.
Umar Kazi is the
Supplier, Lordship.
one of the accused.
Lordship.
But he is not yet taken into custody. Because right now in custody is the truck driver who carried the contraband, and I was the person who was following the accused person. And 3 other person are left on this one. And right now the stage is set for only appearance stage. And the next
Charge
date,
sheet has been laid.
yes, I see that final report has been laid, my lord. And the next date is fixed on 14/5/25 for appearance.
Investigation is over.
Over.
You
And
could
I'm
not
behind
collect
the
anything except co-accused.
co-accused statement. And that when it is not.
Materials are there, Lordship.
What material?
The CDR is there, Lordship. Bank statements are there, Lordship.
I'll pay
And
that,
it's,
my lord.
Lordship, it's a 5.264 kg of heroin. That is commercial quantity, Lordship. That cannot be.
No, those things are okay.
Lordship.
But to connect the accused,
Yes.
he was following in a separate vehicle. You have to show that he was escorting. He was knowing that the vehicle is being carried in the vehicle which is going ahead of him.
He was following the truck, Lordship. That is.
So anybody who follows a truck.
Lordship, he
from
was
a-
in contact with the supplier also. That is
So
also
those
there, Lordship.
materials are necessary.
Right.
Linking material.
Lordship can file the case file, Lordship. Also, Lordship, 37 embargo is there, Lordship. That has to be fulfilled, Lordship. And it's also there in Kasif judgment, Lordship. Has perused that judgment. 39, para 39, Roman 1 and 2, Lordship. The provisions of NDPS Act are required to be interpreted, keeping in mind the scheme, object, and purpose of the Act. Also, the impact on the society as a whole.
No, okay. Those things are okay. You show something.
So these are the materials available with me right now, Lordship. After considering the Lordship, these things, Lordship can pass the necessary order.
Today, I have completed my 1 year, 6 months, 12 days, and it is still in appearance stage. So the trial will take a lot of time, my lord, to conclude. And your lordship in that Gautam Shah's case, 2024 5 GLT, I have given the record, my lord.
Heard Mr. Z. Kamal, learned senior counsel, assisted by Mr.
S.J. Chaudhary.
S.
J. Chaudhary.
S. J. Chaudhary, learned counsel for the petitioner. Also heard Mr. A. Jain.
K. Jain.
K.
Quashing
Jain. K. Jain, learned counsel for the NCB. This application under section 483 of BNSS 2023 has been filed by the petitioner Rafiqul Islam, who has been detained behind the bars since 31/8/2023 in connection with NCB crime case number. No, in connection with what is in connection with special NDPS case number 39 within bracket N/2024 corresponding to NCB crime case number NCB crime case number 15/2023 under section 8 within bracket C/21C/27A/29 of the NDPS Act 1985. The gist of accusation in this case is that on on 29/8/2023 at about 1700 hours. One Mr. J. Tau Thang, former intelligence officer of NCB, received an information through reliable sources that two persons, namely Shamir Uddin and Rafiqul Islam, will be arriving in a vehicle within bracket truck, bracket close, bearing registration number NL07A3351, carrying about 4 kgs of heroin. Accordingly, after performing the necessary procedural requirements, a police team was formed and it it conducted a search operation near Borghat Sareli, Nagaon. In the intervening night of 30/8/2023 and 31/8/2023, the one vehicle bearing registration number from which vehicle the
Truck, my lord.
truck NL07.
Yes.
NL07 A 335
NL07A
3351 was intercepted. So the vehicle was followed by a blue color TVS Apache motorcycle bearing registration number AS21G3339, which was driven by the present petitioner, Rafiqul Islam. During search of the truck, total 5.264 kgs of suspected heroin was recovered therefrom in 235 numbers of soap cases. Thereafter, when you filed the final complaint,
Final complaint.
22/2/22/2024.
In item serial number 7, my lord, of my list of dates.
thereafter, you have given a list of dates.
Yes, my lord, I have given the list of dates, my lord, already there. Serial number 7.
Thereafter, on 22/2/2024, the NCBs filed the final complaint against 5 members of accused persons, including the petitioner, Rafiqul, including the present petitioner, under section 8 within bracket C/21 within bracket C/27 within bracket 27A and 29 of the NDPS Act. learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in this case, as nothing was recovered from his possession. Stop. The petitioner, learned counsel for the petitioner submits that there is no material on record except the confessional, except the statement of the co-accused, statement of the accused persons recorded under section 67 to implicate the present petitioner in this case. He has further submitted that the petitioner has been languishing behind the bars since more than
1 year, 12 days.
6 months. However, till date, even charges are not framed.
Appearance is not even complete.
Even charges are yet to be framed. He therefore submits that the petitioner is entitled to get bail on the ground of prolonged incarceration.
I have given the judgments.
Okay. Court paragraph 9, number 9 from bail application number 3266/24. Please, black mark for us. Para 9. On the other hand, Mr. K. Jain, learned counsel for the NCB, has vehemently opposed the grant of bail to the present petitioner on the ground that huge quantity of suspected heroin has been recovered in this case. And as the quantity of heroin recovered is of commercial quantity, the embargo of section 37 of the NDPS Act is applicable. He also submits that apart from the statement recorded under section 67 of the NDPS Act, the all detailed reports within bracket CDR of the phones of the present petitioner analysis shows that the petitioner was in constant touch with
Omar Kazi,
who is the main supplier of the seized heroin. Regarding incarceration,
Lordship, regarding incarceration, I have the judgment of Kalyan Chandra Sarkar, Article 21. Mere long incarceration is not a ground for the grant of bail, Lordship. It's a 3-judge bench judgment of the Supreme Court, Lordship.
This is Gautam Shah's case. Your lordship has dealt with it, madam.
in case,
And Shahidul Islam, madam.
you have that judgment.
Gautam Bishas is already given, madam. I've got the Gautam Bishas from para 16 to 25, madam. Your lordship has taken all those things into consideration, madam. The Honorable Supreme Court of India in Mohammed Hussain versus State reported into an online on the grant of bail of the ground therefore delay in trial cannot be said to be fettered by section 37 of the NDPS Act. That is also there. madam. So the one which is beneficial.
Kalyan
Chandra Sarkar.
No, that is in a murder case, madam, the politicians. Not for NDPS.
But the Article 21 has been elaborated there, Lordship.
learned counsel for the petitioner, Rajiv Ranjan.
I have also given a write-up of the judgments, pilot probably it's in the file, madam.
Where?
I'm relying on Gautam Shah, then Saidul Islam, and section 36(1) of the NDPS Act, madam, wherein it is categorically stated that special courts are constituted for speedy disposal of case. Just reading the first line, madam. Constitutional court, the government may, for the purpose of providing speedy trial of the offence under this act by notification, the officer that constitutes as many special courts.
Code para 13, 14, 15. 16, 17, 18, 19, 20 from the
In
this
Kundan,
judgment.
Papu Yadav case, my lord, it was a hang and murder case.
3266/2024. I will deal with that. Yeah, the paragraph and control facts. One of the value. You are allowed to go on bail of rupees 2 lakhs. 2 sureties of life.
Much of it.
Incomplete hoy থাকে, huh? বাকি আছে detention. Part.
May please allow. Lord, all these petitioners, President, General Secretary, and members of the Nagaon Bar Association, my lord. Now, what had happened, my lord, there is a lawyer, my lord, his name is Hussein Muhammad Rizwan. He is also a member of the bar. My lord, he was caught red-handed while selling drugs. Then, my lord, when it was noticed by some of the lawyers, then they grabbed him, confined him in a room. Then the police was called. Then, my lord, police came, recovered drugs. Then, my lord, he was arrested. He was charged sitting. Now the trial is going on. Now, my lord, his wife has filed an affair based on which now, my lord, the police is proceeding against us. Now, as far as the, my lord, affair pursuant to which, my lord, the Mr. Hussein was arrested, that your lordships will get at page number 25. I have the honor to inform you that today at about 3:30 p.m., Advocate Asadur Rahman is petitioner number 3, my lord. Then Badrul Islam, petitioner number 5, are coming from court towards bar. And while reaching the bar, generator said this, they have noticed that the below noted accused is about to hand over a white color packet to an unknown person and suspected to be NDPS heroin. They immediately asked the accused why he sold NDPS substance. The unknown person has managed to escape from the place. Nearby the PO, other 3 advocates, namely Mohammad Parvez Chaudhary, so-and-so, and 2 others were also eating misal. Asadur Rahman, Badrul Islam, and Chaudhary so-and-so caught red-handed the below named accused with drugs and had taken him to the bar office. At the time, the bar employee Middleborough called me and President H. Kondekar to the office room where the accused is kept. Immediately, Advocate Inamul Ansari, Pankaj Hazarika also entered in the bar office room. We all noticed 2 white powder packet in the inside pockets of the accused pant. Another packet was kept under his shirt by him, which he opened and kept open the table in front of us. I informed Nagaon PS, and hearing he has kept the 3 packets in front of us on the table, and suddenly he has torn 2 packets on the carpet of the room on the floor in front of us to disappear conceal evidence. We have noticed that the 3 packets of suspected drug heroin, approximately 450 grams. Accused repeatedly tried to escape, flee from the room, so he is kept inside by bolting the room, and we all are guarding him so that he cannot flee away. Police has arrived in the office room of the bar where the accused is kept, and by saying the police, he has suddenly torn up the 3rd packet in front of the police personnel and seizure witnesses. Advocate Badrul Islam has written the affair as dictated by the informant in front of the police and witness. Somebody has clicked photograph of the white colored suspected heroin while 3 packets were kept on the table by accused and before destroying the evidence of the accused. Accused has threatened us in front of the police personnel. The police personnel has seized the remaining portion of the suspected white color powder along with the piece of carpet where the drugs were available after tearing the packet by the accused in presence of the seizure witnesses and us. The accused by tearing the packet committed an offense under section so and so. So I request you to be kind enough to, and my lord, this was the FIR lodged against Hussein Mohammed Rizwan. Now he has been charge sheeted, my lord, that we have annexed. Now what had happened? Wife of that my lord accused, he lodged this FIR. Kindly come to page 47. At page 50 rather, my lord. With due respect, I would like to submit. Oh, sorry. 47 million, I'm sorry. I'm sorry, Mira, 47.
Yes.
That, sir, it is respectfully submitted that I am a permanent resident of the aforesaid address. My husband, Hussein Mohammed Rizwan, is an advocate practicing in Nagaon and different other places of Assam. A few days ago, my husband lodged CR so-and-so against accused number 1 because accused number 1 had publicly defamed my husband by accusing him of engaging in dalali. Additionally, the accused is also facing trial in Nagaon. Both these cases are stayed by this honorable court. Again, my lord, because this aspect was highlighted, then he filed a defamation case and which has been stayed. For the last few days, the accused number 1 has been threatening to kill my husband in various ways. Today, that is on 5/7/23, while my husband was working in Nagaon court, accused number 3 and 5 grabbed my husband in front of court number 6 of DC office and dragged him to Nagaon bar office. They took him to the chamber of the accused number 1, and on his instruction, they tried his arm and legs and also tied his eyes. Thereafter, accused person inhumanly beat my husband with the intention of maiming him for life and causing serious injuries to his ears, mouth, and head by kicking him. The accused number 1, with the assistance of other accused, forcibly attempted to put some drug-like substance in my husband's mouth. Additionally, accused number 1, with the assistance of other accused, attempted to put packets of drugs inside my husband's vest. However, in the scuffle, the drug packet got torn and fell. Further, accused number 3, 4, and 5 stands my husband's gold ring, which he was wearing on the right hand, along with the cash of rupees 7,500. Accused number 6 and 7, on instruction of accused number 1 and 2, attempted to break the arm and legs of my husband. The accused persons intending to implicate my husband in a false case had conspired to act in this manner, and they had endeavored to mislead the police. It is therefore prayed. So, my lord, we all know, my lord, when malicious complaints are filed, my lord, enough care is taken to see that the ingredients are there. In the recent two judgments of the Supreme Court, my lord, the Honorable Justice Pardiwala has pointed this out. Therefore, it says, my lord, whenever such complaints are before the court must be more careful and find out actually what really is the state of affairs. My lord, here is a case, a person has been caught red-handed for selling drugs. Now his wife is saying that president of the bar, secretary of the bar, other members who caught him, they have done all these things, my lord. And that is the case is all about. But kindly see the falsity in the claim, my lord, page 50. Now this is the, my lord, police inspector's report, inquiry report. Now this will reveal the truth. With due respect, I would like to submit that based on FIR lodged by Mohsina Firdausi Begum, that is the wife of my lord that accused, I conducted a local investigation and it has been confirmed that the informant's husband, Hussein Mohammed Rizwan, was dragged in front of room number 6 and thereafter confined by the accused named in the FIR along with other members of the bar. Therefore, I humbly request that a case be registered and further details be revealed. So, my lord, this report does not indicate all the allegations which lordship finds in the FIR. It's a fact. He was caught red-handed, then he was taken to the other room. So that until the police comes, he was detained there. No, my lord, the police has submitted a charge sheet, my lord.
Against all the...
Yes, my lord. The president, secretary of... My lord, it would have been better if you would have kept mum. Now, my lord, 57, my lord. All along, my lord, impression was given. Since we have given, my lord, charge sheet in the other case, we'll give a final report. Now we find this. at
Police-
page 57.
Police must have found the truth in investigation.
Kindly see, my lord. Brief facts of the charge sheet are as follows. On 13/7/23, FIR lodged by informant Mohsina Fidel so Abdul Hassan Khandakar as the president, Asadur Rahman, Badrul Islam, Chaudhary, Parvez so Ujit Kumar Bora, Harisul Zaman, Nakibur Rahman, and Dibojyoti Mondo was registered as Nagaon PS case number so. During course of investigation, the place of occurrence was visited and statement of witnesses were recorded. In case course of investigation, sufficient materials substantiating charge under 143, 341, 342, 323, 506 IPC was found against the accused so and so, so and so, so and so. So this is the case. Well, it would be nothing but an abuse of the process of the law. And Lord Lordship knows that recently the Supreme Court in one of the judgments said that when the informant is conscious of the fact, and especially when is the wife of an advocate, my lord, she has taken care to ensure that while writing the allegations will write in such a manner that it covers some of the offences alleged. Therefore, the Honorable Supreme Court says, my lord,
No, but
I'll just rely on that paragraph.
before you,
Milord.
there's one query.
Yes.
This is not a case where only lodging of the FIR and then investigation is pending.
Yes.
After the investigation, charge sheet has.
Yes, my lord.
And charge
So
sheet
my
has.
humble submission is, my lord, Lordship will that's why Supreme Court has said, my lord, in such nature of cases, Lordship will have to take extra care to find out what is the actual state of affairs. Let them come up with their case, my lord. If your Lordship will kindly come to para 24, my lord. Para 26. At para 28. My lord, after referring to Bhajan Lal and all, at this stage, we would like to observe something important. Whenever an accused comes before the court invoking either inherent power under 482.
You are reading para 26?
Para 28, my lord.
28.
Yes. Last page. Last but one page.
Yes.
Has the Lordship got it, my lord?
Yes.
At this stage, we would like to observe something important. Whenever an accused comes before the court invoking either inherent power under 482 or extraordinary power under 226 to get an FIR or criminal proceeding was essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with ulterior motive for wreaking vengeance, then in such circumstances, court owes a duty to look into the affair with care and little more closely. We say so because once the complainant decides to proceed against the accused with an ulterior motive for wreaking personal vengeance, then he would ensure that FIR complaint is very well drafted with all necessary pleadings. The complainant would ensure that the averments made in the FIR complaint are such that they disclose the necessary ingredients to constitute the alleged offense. Therefore, it will not be just enough for the court to look into the averments made in the FIR complaint alone for the purpose of ascertaining whether necessary ingredients to constitute alleged offense are disclosed or not. In frivolous or in vexatious proceeding, court owes a duty to look into many other attending circumstances emerging from the records of the case over and above the averments, and if needed be, with due care and circumspection, try to read in between the lines. The court, while exercising its jurisdiction under 482 or under 226 of the Constitution, need to restrict itself only to the stage of a case, but it is empowered to take into account the overall circumstances leading to initiation, registration of the case, as well as materials collected in course of investigation. Take for instance, in the case on hand, multiple affairs has been registered over a period of time. It is in the background of such circumstance, registration of multiple affairs assumes importance, thereby attracting the issue of wreaking vengeance out of private or personal grudge as alleged. So here is a case, my lord. Our specific case is because her husband was caught red-handed, now she's trying to wreak her personal vengeance. So therefore, my lord, the Honorable Supreme Court says that in such cases, lordship will look at the attending facts and circumstances. The attending facts and circumstances is her husband was caught by these persons because he was dealing with drugs
Okay.
in court premises, in court dress.
Okay, but during investigation, the IO collected some material.
Lordship will kindly see, my lord. My lord, every investigation does not lead to conviction. My lord. Yes, it's true. I'm not saying that. But my lord, it is an exercise which is done very perfunctorily, my lord. All along, we are given to understand that once the other case is charge sheeted, there will be a final report. We do not know what had happened, my lord. No, lordship will at least examine the case, let them produce the case that what
Yes.
materials
For
are there.
that, we have to peruse the case diary.
Yes, certainly, my lord. Only thing is, my lord, meanwhile, further proceedings may be stayed, my lord. Otherwise, my lord, we are all respectable members of society. The president and secretary of the Bar Association is before lordship, my lord. Lordship will.
No, but what is the criteria of staying, giving interim stay?
No, my lord, my humble submission is, since prima facie it's a case which is a vexatious proceeding, which has been instituted only to wreak personal vengeance, which is evident from the attending facts and circumstances. Therefore, lordship will protect us in the meantime, my lord. It's a private complaint, kindly see, my lord.
Yes, it is a private complaint. The wife might have exaggerated fact, like
Yes.
planting of drugs. But some of her allegations were found to be true.
My lord, we are not disputing that. Yes, normally if a person who is having drug, if he is sought to be taken hold of, he will definitely resist. In the process, there will be some use of force, etc. My lord, whether in the end of the day, whether it was an attempt to commit a crime, prima facie there is no material. What does the police report says, my lord? The inspector's report says otherwise. Kindly see, come to page 50. That's why I'm saying lordship will take note of the attending facts and circumstances. With due respect, I would like to submit that based on FIR lodged by Mohsina Firdausi Begum, I conducted a local inspection and it has been confirmed that the informant's husband Hussein Mohammed Rizwan was dragged in front of the room number 6, thereafter confined by the accused. So, my lord, if we take this statement to be correct, what offense is there, my lord? He was dragged, yes, because he was resisting, therefore he was dragged. And yes, he was confined because we were waiting for the police to come. So if this is what police and found following first-hand information gathering, why will lordship believe what is written in the FIR, my lord, prima facie? And also having regard to the attending facts and circumstances. Clearly says, my lord, only allegation is he was dragged. Yes, of course he was dragged. And he was confined. There was no illegal restraint. There was no wrongful confinement within the meaning of, my lord, the sections indicated in the FIR. (341) and 342. Therefore, my humble submission is, my lord, lordship will certainly examine the matter and protect us, my lord. Otherwise, my lord, they're all.
But why lawyers need protection?
My lord?
Why lawyers need protection? You can defend yourself before the court.
No, my lord.
You are not.
End of the day, a process has been issued by the court of law. That's why, my lord.
You are able to defend yourself.
No, it's not a question of lawyer defending himself or he is being defended by others. Certainly, Lord, if your lordship, after hearing the matter, finds that it's a case where trial should proceed, definitely we'll have to face the trial. But all that I'm trying to submit for lordship's kind consideration is, in the facts and circumstances of the case, is it not a vexatious, complaint, my lord? And more so, when the, my lord, in fact, my lord, section 43 of the CRPC, in fact, confers power on citizen to arrest somebody if he is found in section 43.
To use force also.
My lord.
By using force.
This is if necessary. Is it a case whether he has suffered any injury on account of that? My lord, the police says he was dragged. Yes, he was dragged. Not dragged in the literal sense, but because he was resisting, therefore, 2-3 advocates caught hold of him and took to that particular room, and he was detained there for some time until police arrived.
At what stage the case is pending?
Appearance.
You are on bail?
Yes. Anticipatory bail.
All of you are on
all
bail.
of us. Follow.
Then where is the necessity of interim relief?
No, my lord, I'm saying that further proceedings of the entire proceedings should be stayed, my lord.
We will stay it after going through the case diary.
No, my lord, till then lordship will protect us, my lord.
No, you have to protect somebody who is vulnerable. Why you are seeking protection?
Lord, it's not a question of protecting vulnerable. It's a question of giving legitimacy to a proceedings which has been initiated by somebody. A wife of an accused who is dealing in NDPS, she is filing a false complaint. I am complaining against that. That's why Supreme Court says merely because the complaint contains allegation which fits into the scheme of a particular offense, that is not enough. In such a case, the court has a duty to look into the matter, deep into the matter, and to look into the attending facts and circumstances. When your lordship looks into the attending facts and circumstances, what clearly transpires is that it is an attempt to take revenge, because you have caught hold of my husband, we'll teach you a lesson now. That is what has happened.
Yes.
Lordship, what I have seen in the FIR, Lordship, it is stated that the date took him to the chamber accused and instruction date tied his arms and legs. Thereafter, the accused inhumanly beat up husband with the intention of maiming him for life. There are many allegations of beating him. And it is also ascertained till now, Lordship, that they were present, and what had happened between this period that this person has caught hold. And between that period, Lordship, it cannot be denied that nothing has been done. No offense has been made, Lordship. Moreover, Lordship, in case of 482, Quashing, it's a fit case where no prima facie material is there. But if you're looking into the FIR only, Lordship, charge sheet has already been filed, Lordship.
No, here the case is little bit different.
Lordship.
The husband of the informant was caught red-handed
that may
while
be
possessing.
That is a suspicion only. That is a suspicion on that
Against
ground.
him, charge sheet has been filed.
Lordship, it is true that it only creates a suspicion, but it does not deny that no offense has been created, Lordship. It is just a mere suspicion. It will be looked into the trial, whether this offense has been created, made or not, Lordship. The trial will look into it, Lordship. But at this stage, trial should be done, Lordship. Because prima facie material is there, Lordship.
2nd of May.
We'll fix the notice before that.
Only thing is, my lord, I was only saying these are all respectable members of the bar, prima facie, my lord.
But if we list the matter before 2nd of May, then whether there would be necessity of any interim. If you can satisfy me that.
Only thing I was thinking, my lord, they'll have to appear in the dog, this and that, and can you see the circumstance? Anyway, I leave it to your lordship, my lord.
Heard Mr. A.N. Chaudhary, learned senior counsel for the petitioner, assisted by Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by 7 numbers of petitioners who are members of Nagaon Bar Association, praying for quashing of the proceedings of PRC case number 1113/2024, pending in the Court of London Judicial Magistrate First Class, Nagaon. Learned senior counsel for the petitioner has submitted that the FIR on the basis of which charge sheet has been laid in the PRC case number 1113/2024 was lodged by the wife of an advocate against whom who was found wife of an advocate, namely what is the name of that advocate?
Milord. Hussein Mohammed Rizwan.
Hussein Mohammed Rizwan, who was found possessing prohibited drugs and was apprehended by the members of the Nagaon Bar Association on 5/7/2020. Stuff. Learned counsel for the petitioner, learned senior counsel for the petitioner has submitted that the FIR against the present petitioner has been filed by the wife of the said advocate to wreak vengeance against the present petitioners who had apprehended her husband with drugs. Learned counsel for the petitioner has submitted that two of the present petitioners lodged the FIR against Hussein Mohammed Rizwan, and on the basis of the FIR lodged against Mr. Hussein Mohammed Rizwan, an investigation was initiated and charge sheet was also laid against him. So. Learned senior counsel for the petitioner has submitted that since the since the criminal proceeding against the present petitioner has been initiated, which is manifestly frivolous or vexatious, and with an ulterior motive of wreaking vengeance only, same requires interference of this court. And he seeks interim protection by staying the proceedings of the PRC case number 1113/2024 during the period during the time taken for issuance of service of notice on the respondent side. On the other hand, learned additional public prosecutor Mr. K.K. Das has submitted that as this is a case where charge sheet has been laid after investigation which followed after filing of the FIR, the court should be slow in invoking its jurisdiction under section 528 of BNSS. After considering the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor, this court is of considered opinion that scan copy of the PRC case number 1113/2024 as well as scan copy of the case diary of Nagaon PS case number 642/2023 would be required for consideration of this bail application. Hence, call for the scan copy registry to take steps for issuance of scan for requisitioning the aforesaid scan copy. learned counsel for senior counsel for the petitioner has submitted that the next date of the case is fixed on May
25.
2nd of May. Stop. As this court intends to fix the next returnable date of the notices issued to the respondent side, respondent number 2, before the said date of appearance, the question of interim relief at this stage does not arise.
Lordship,
I am fixing the case before 2/5. Therefore, interim relief is not considered at this stage.
or Lordship, I keep the matter for consideration interim matter on next date, Miller, after receipt of the case.
That may be done.
Lordship has fixed a date, Miller.
Yes, let this case be listed on 22nd of April. 22nd of April. The question of granting interim relief shall be considered after service of notice on respondent number 2, as well as the receipt of the scanned copy of the case records, as well as case file. List record.
Maybe Lordship, my lord, this matter may kindly be adjourned for that day, my lord. I need some more preparation, my lord. And I also need some more instruction from the client.
Heard, Mr. Item number?
10, my lord.
Heard, Mr. A.R. Talukdar. Learned counsel. You are Mr. Talukdar.
My lord.
And who is for?
I am for respondent number 2 and 3, my lord.
Also heard Ms. L. Wazida.
My lord.
Learned counsel for respondent number 2 and 3. As well as Mr. K.K. Das, learned additional public prosecutor. The learned counsel for the petitioner has prayed for an adjournment for the day due to some personal difficulties, to which learned counsel for the respondent number 2 and 3 does not oppose. Hence, the prayer is allowed.
Next week, my lord.
A date may kindly be fixed, my lord.
No, let this matter be listed after 2. In the 3rd week of March. In the 4th week of March.
My lord.
On a date to be fixed by registrar.
Oblige.
Oblige.
CRP मौजूद करने के आगे. This case is odd man out. In a criminal bench, this is a civil case.
Sir, my lord, what is to be done?
How much time will you take?
At least 20 minutes, my lord. Matter is otherwise simple, my lord. Both are connected. If your lordship permits me 2 minutes, hear me. If your lordship thinks that it may require further hearing, then I will get a specific date fixed, my lord. What has happened, my lord? There was a suit between a landlord and a tenant. The landlord filed a suit on 2 grounds, seeking eviction. First, that there is default in the payment of rental. Second, bona fide requirement. During the pendency of the first suit, the tenanted premises got gutted down in a fire incident, my lord. I am the tenant. I filed a suit against my landlord saying that it needs to be repaired and restored back to its past glory. Both the suit run simultaneously, my lord. Thereafter, there are many other developments which perhaps is not required for the adjudication of the dispute, my lord. Thereafter, what happened? Evidences were recorded in both the suits. Ultimately, the suit was fixed for argument. At that stage, in 2022, the suit relates to 2010 and 2011. 2010 is the first suit filed by the landlord. 2011 is the second suit filed by the tenant. At the 2022, the son of the landlord, after the death of the landlord, he came and he informed the court that this suit property was sold in the year 2016 itself. So far my suit is concerned, the suit filed by the landlord, I am not interested to pursue, and the subsequent purchaser may kindly be impleaded as the purchaser, and he may kindly be allowed to continue with the suit. Who was the purchaser, my lord? He happened to be one of the witness who adduced, my lord,
But he himself was not,
interested. He
and
informed the
neither
court
he
by
was
the
the
petition.
party.
My lord.
His father was
The son appeared representing all other legal representatives of the original landlord, informing the court that I have been continuing with the suit even after death of my mother, who happened to be the original landlady. But now I have come to know that this suit property was sold way back in 2016. Therefore, I am not interested to pursue this matter, and in place of me, the purchaser may kindly be substituted. That was the application. So far, my suit, the suit filed by the tenant is concerned, there the original landlord was quite obviously the defendant. There also a similar petition was filed saying that I cannot continue to be the defendant because the property has been sold, and whatever relief the plaintiff, the tenant is seeking against me may kindly be sought against the purchaser. So far the purchaser is concerned, my lord, it is not that he was totally ignorant about this development, and he never approached the court, the trial court. He was one of the witness on behalf of the landlord who adduced evidence in 2014. And in his sale deed, it is reflected that a matter is pending in the court. Despite that, he purchased the property. And since 2016 till 2022, even till today, the purchaser has not come to the court. Now, so far my suit, the suit by the tenant is concerned, I am the dominus litis. I cannot be compelled by the trial court on the application of the original landlord that I should replace so-and-so in place of so-and-so.
Yes.
And so far the other suit is concerned, my lord, the landlord or the legal heirs of the landlord, if they are not interested to continue with the suit, they have every right to discontinue. But they cannot come and suggest to the court that in place of me, substitute him when this gentleman is not before the court.
Correct.
So that is my case. The Supreme Court, my lord.
okay, then you give your argument is finished.
That is my argument, my lord, supported by some legal judgments, my lord.
You give a written argument. I'll fix the judgment
My
for.
lord.
This
My
is the gist of your case.
This is the gist, my lord.
That in one case, you cannot be forced.
Because I am the dominus litis?
Yes. In other case,
He
they
is
cannot
free.
impose.
He is free to withdraw, but he cannot suggest
There
whom
is-
to take in his place. When the gentleman is not
He's
interested.
not approaching.
When the other party, the transferee is not approaching, the assignee is not approaching. That is my case.
Because this is kept part of since long. Now, why CRPIO?
Because arising out of an interlocutory orders, my lord. The suit is still pending. It's not an appeal, my lord. It is under 227. Because the court allowed both the application.
And you are impugning that application.
My lord.
So only setting aside the impugn order would do.
Only setting aside, along with that, I have also made a prayer, your lordship, that the sale itself is illegal in view of the fact that in my suit, there was an order of injunction asking both the parties to maintain status quo so far possession is concerned. So I have also made an application before the trial court that the sale deed itself is a nullity because it has been executed in violation of the injunction order. That was never considered. So I have twofold prayers, my lord. First.
But for that, you have to file a suit.
No, my lord. The apex court said that in case if there is any execution of any deed of whatsoever nature in violation of any injunctive order, preventive order, it is in the teeth of the order and therefore it is a nullity. And that can be declared in ancillary proceeding also. For that, there is no necessity of filing a separate suit or separate proceeding. But the court has to come to a conclusion whether it is in the teeth of the order that was passed. That exercise was not carried out by the learned trial court.
The second prayer
If
is
your lordship thinks fit, Kindly fix a date, my lord. I will come with my written argument.
Yes.
I will provide it on that day, my lord.
Because
Thereafter, your lordship can fix for
second prayer is little bit complicated.
my lord.
Heard Mr. S.K. Singh, learned senior counsel assisted by Mr.
B. Pusila.
B. Kushila, learned counsel for the petitioners. This court heard Mr. Singh, learned senior counsel for the petitioner for some time. And in the course of the hearing, it was felt that it would be convenient if the counsel for petitioner submits written arguments in this case. Hence, for which learned senior counsel for the petitioner prays for some time. The prayer is allowed. Let this matter be listed in the month of April.
Well, either 21st of April or 22nd.
Let this case be listed on 22nd of April as part heard matter.
Obliged.
Fourteen, 15, same, my lord, similar, out of same, In this case of what happened, my lord, your lordship can say the FIR file written by somebody else. My lord, the informant, he himself filed an affidavit saying that, my lord, the names which have been incorporated in the FIR actually are not known to me.
Where is the FIR?
Yes.
What you are challenging?
My lord, yes, page 15, man. I have come for quashing of this FIR, man.
Whether records have
in 15, I think scan copy has come, I think. Huh?
Not come.
Huh? Or called for.
Yes, there would be necessary scan copy.
In the meantime,
You are appearing for?
I'm appearing for respondent number 2, Lordship. Lordship, I have filed affidavit in opposition, Lordship, to annex the one affidavit, Lordship, which was exhibited on 2018, Lordship. Lordship, kindly come to my.
You are opposing.
No, Lordship, kindly come to my affidavit.
this support affidavit is given by them immediately after the FIR was filed.
Yes, Lordship.
That these names have been included by somebody else, by the writer.
Yes, Lordship.
Advocate clerks. I have not named them. I have not seen them. Far away.
Lordship, kindly come to my affidavit.
Then this is not an affidavit in opposition.
So it is not affidavit position, man. So this is the case, man.
Affidavit in support
Yes,
of the
yes,
petition.
support, man. Right.
Then we have to call for the scan copy of the records.
In the meantime, madam, because actually, in fact, madam, they have filed on oath, they have submitted, madam. They have submitted.
Where is the affidavit?
Lordship, kindly come to my affidavit in opposition, Lordship.
Page 32 starts.
Page 32 start, Lordship. And Lordship, kindly come to 33, Lordship. Paragraph 4, Lordship.
Where is affidavit copy?
Page 33. Affidavit starts from page 32.
Is this stage?
Stage, I think, madam, because nothing progress, madam. Because charge sheet not yet been filed.
No, it starts with submitted.
For charge sheet, sorry,
Starts with
sorry, right.
Repeat.
Rest, I think, nothing for this.
Then let the scan copy come.
And that already your lordship called in that case, item 59.
Both are related case.
Same affair.
Same
Out of
affair.
same affair.
Out of.
There are other person, there.
Okay. Heard Mr. H.R.A. Chaudhary, learned senior counsel assisted by Mr. M. Hussain, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor, as well as Mr. What is your name?
A. Alim Sheikh, Lordship.
A. Alim Sheikh, learned counsel for respondent number 2. Stuff. For consideration of the instant criminal petition, perusal of the scanned copy of the PRC case number 60/2023, as well as scanned copy of the case diary of Swalkuchi River PS case number 36/2018 would be necessary, hence all for the same. List this matter. When?
Yes, because in fact, we lost it in the beginning, so. Because already once the reminder is to go in item of 15, that will be.
Yes.
Yes.
Already called.
So 11th. 11th of
11, next month.
11th of April.
Today is what, today is 13.
Okay.
Lordship, kindly.
This month.
26 or 27 of
27th of March. 27th. In next case,
Both the cases will come together.
this case also.
15 already scan copy called.
Same order.
Same.
Same order. At the office note says that the scan copy of the case record has not yet been received. Issue reminder for scan copy. List this matter again on. Which was the date?
27.
27 March.
27.
Not 27.
Both the cases, because arising out of.
Let this case be. Which is the item number?
Oh, 14 and 15.
Let this criminal petition be listed along with criminal petition number 225/2024 on 27th of March.
This matter is being listed at the instance of respondents, my lord. They file a modification petition, my lord.
Yes, I am appearing, my lord, for the respondents.
What
via
modification?
Modification of the interim order dated 4/11, 6/11/24, my lord.
Interim order was passed in
Revision petition, my
in
lord.
the revision petition.
My lord.
You are the petitioner.
I am the petitioner, my lord.
By which order? 6.
My lord, the impugn order is at page 41, my lord.
Page 41 of
Revision petition, my lord, the impugn order.
in
Annexure
revision petition or interlocutory application.
My lord, there are two petitions, my lord. One is my revision petition, and then subsequently the respondents filed modification petition, that is IA 119024.
No, they have come for
Modification of the
stay order.
stay
Granted
order
by this.
passed by this honorable court.
Where is that stay order?
Stay order, my lord.
That stay order, my lord, is there at my lord, page 14 of my IA, my lords.
Page 14 of their IA, my lord.
In fact, my lord, in the IA, there is an observation of my lord Justice A.D. Chaudhary that the entire revision petition will be heard instead of going by the IA and all, my lords. That is why it has come up for admission before your lordships. So, my lord, it's a short matter. It can be decided, my lords, today itself.
there is a civil suit pending between the parties. The crux of the issue is that when the civil suit is filed, and that is admittedly filed by the other side, the petitioner, whether in view of the pendency of the civil suit, these proceedings can continue. That is the only issue, Manoj.
No, Mr. Ganguly,
Lordship.
the video is not so clear here. So
No,
for final hearing,
I will have to. Then Lordship will kindly have it on 3rd of April, Manoj, because I have suffered an injury. It will take some time, 2-3 weeks perhaps.
okay. Heard Mr. H. Das, learned counsel for the petitioner, as well as Mr. A. Ganguly, learned counsel for the respondent. Learned counsel for both the parties have submitted that though an interlocutory application has been filed by the respondent side for vacating the stay order, vacating/modifying of the stay order passed by this court by order dated 6/11/2024. However, records would not be necessary.
No, my lord, everything we have already brought on record, because this is only an order of the magistrate.
My lord, may I pray, my lord, the executive magistrate's record may be called for, my lord? It is from
Lord, this is an order under 145. My lord, why they want to delay the matter? My lord, this is the intention, my lord. That is the difficulty. Why the record is necessary?
We'll fix it for a final hearing, and we will also issue requisition for records. If
But
records
let it come
come,
up
it
for,
is-
my lord, let it come up for the admission hearing, my lord, instead of a hearing. Otherwise, my lord, there will be difficulty, because there is an urgency in the matter. There is no injunction that they have been denied injunction in the civil suit, but they have a stay order indirectly, my lord, in this matter. That has complicated the issue, my lord, at hand. That is my humble submission, my lord. Because otherwise, my lord, law is well settled, my lord. When the civil suit is pending between the parties on the same issue, admittedly the same issue, 145 has to come to an end. And it has come to an end, my lord. Why this revision should continue, my lord? That is the issue.
However, as both the parties have agreed to make final submission, agreed for a final hearing of the criminal revision petition itself. This court also is of the view that instead of considering the interlocutory application at this stage, the case may be finally disposed of on a date which is agreed upon by both the parties. Stop. Let the records of Miss Case number 130/2023 be called for from the Court of Learned Executive Magistrate, Lakhimpur, North Lakhimpur. Let this case be listed for final disposal on which date?
My lord, 3rd of April, as your lordship has fixed.
3rd of April, my lord.
3rd of April.
3rd of April.
3rd of April, list accordingly.
No, in the admission column, my lord.
In the admission hearing column.
Lord.
Yeah, Your Lordship. My lord, I'm appearing for the respondent for the first time today, my lord, and I have gone through the brief, my lord. I need some concern with my clients, my lord. So if necessary, I'll file one affidavit. So I'm praying for some time in this matter. And since the learned petitioner is on interim, my lord, the interim may be continued.
Heard Mr. G. Alom, learned counsel for the petitioner. Also heard Mr.
P.K.
Deka, learned
For the
counsel,
respondents.
appearing for how many respondents?
2, my lord.
For both the respondents. Learned counsel for the respondent has submitted that since he has been engaged by the respondent recently, he needs to take some instructions
my lord,
from the respondent before making his submissions in this case. The prayer is allowed. Whether record would be, what is being challenged?
My lord, in this case, my lord, the order, the interim order, my lord, page 88, my lord, where the interim order, my lord, has been vacated, my lord, without giving an opportunity to the petitioners, my lord.
Okay, okay.
Record can I go, so in the meantime, record may be called for. My lord,
No,
record necessary.
record.
Yes, my
Yes.
lord. Record may be called for.
You are on interim.
Yes, my lord. I am okay. Scan copy.
Let this scan copy of the
Yes, my lord.
case number 849M/2024 be called for from the Court of London Additional District Magistrate Kachar. Stop. Let this case be listed after 2 weeks.
Like, can it be on 3 weeks, my lord?
After 3 weeks on the date to be fixed by registry, the interim order shall continue till.
Deeply obliged, my lord.
May it please, your lordship. Well, it's a Jimma petition, my lord. Case 40, my lord. Jimma was rejected, my lord. Of some petroleum product and one truck, madam. May I read the order, madam?
But whether revision lies,
My lord, it's an application under, my lord,
227.
438 and 442 of the
Whether
BNS.
448 lies, 438 lies.
With
This is an
section,
interlocutory order.
it's interlocutory.
Jimma, whether Jimma application is an interlocutory order. You answer this query. Jimma is an interlocutory order,
That is,
to my understanding.
because that is always subject to certain conditions, my lord.
Yes, and it is not final.
And in the final, that may be confiscated also, my lord, after completion of the, my lord.
And under,
Because-
against interlocutory order 438 clause 2 bar is there.
Yes. So my friend has written, my lord, an application filed under section 438, 442 of the BNSS, read with section 528 of the BNSS.
But this is not an application under 520. If it is barred by, you come up with answers.
Yes.
What to do under such circumstances.
Then in that case on Monday, madam.
Mr. N.J. Labdafta, Learned Counsel for the petitioner. Also Mr. D. Das, Learned Additional Public Prosecutor. On request of Learned Counsel for the petitioner, let this matter be listed on 17th March 2025. On that day, the petitioner shall make his submissions regarding maintainability of the instant application in view of the bar of section 438 within bracket 2 of BNSS. Please recording.
The next case of same one. Two cases are dead.
Same
Same,
order, common order.
58 and 59.
Common order.
Common order.
There is a correction of the date, madam. It should be 2024 instead of 2020, madam. I've seen in paragraph 3, madam.
IAP 44 nahi. Okay.
Next sentence. Paragraph 3.
Which, where is the error?
Annexure A, page 7, page 8,
Page 8, para?
Para 2, there should be a para 2. There should be NDPS case number 115 oblique to, it is 2020. It should be 2024,
Okay, in line number 4,
Yes, line number 4,
heard Mr. G. Bora. No, B. Bora, learned counsel for the petitioner, also heard Mr. D. Das, learned additional public prosecutor. This interlocutory application has been filed by the petitioner seeking modification of the order dated 10/3/2025 passed by this court in bail application number 3243/2024. Stop. Learned counsel for the petitioner has submitted that in the order dated 10/3/2025 passed in bail application number 3243/2024. An inadvertent typographical mistake has crept in line number 4 of paragraph number 2 of the said order, where the special NDPS case number has been mentioned as 115/2020, whereas it ought to have been 115/2024. Stop. As the aforesaid error appears to be an inadvertent typographical mistake, same need to be rectified. Stop. I have considered the records, and it appears that the special NDPS case number mentioned in line number 4 of paragraph number 2 of the said order should be read as 115/2024. Therefore, it is ordered that in order dated 10/3/2025 in bail application number 3243/2024, the NDPS case number 115/2020 mentioned in line number 4 of paragraph number 2 shall be read as NDPS case number 115/2024. This interlocutory application is accordingly disposed.
Deeply addressed. Deeply addressed.
Thank you.
It's okay, that's it. Ready? Both of you are ready. You have 45 minutes time. Within that time, you have to finish. Mr. Das, you are ready.
Paper books? No, I won't.
If amicus is ready, then it will help you. He may help you. Yes, Mr.
Lordship, appellant was convicted under section 4 of POCSO as well as 366 of the IPC for a period of 10 years under section 4 of POCSO and 7 years under section 366. And petitioner is in custody since the date of his arrest, Lordship. That is from 2021. Till date, more than 3 years in custody, Lordship. Lordship, Azaharet's it is a full Lordship.
Deeply obliged, Lordship.
Cause this.
In this case, get it counsel. One Chaudhary appeared, but his name is not shown. Perhaps he's absent today because his name is not there.
Third, Mr. D. Burua. You are
D.
Mr.
D. Burua.
D. Burua, Lalit, D. Dutta page. First and second. Lalit. Name has not been reflected.
Yes, legal aid counsel, Mr. Ujjwal Chaudhary.
Also, Mr. D. Das, London, additional public prosecutor. It appears that by order dated 20/2/2025, Shri Ujjwal Chaudhary was appointed as legal aid counsel to represent the informant. However, today his name has not been reflected in the cause list as the legal aid counsel for the informant. Perhaps therefore he is not present in the court. The registry is directed to reflect the name of the Ujjwal Chaudhary in the cause list as legal aid counsel for respondent number 2 henceforth. Release this matter.
First week of April, Lordship.
The first week of April.
A date may kindly be fixed, Lordship.
On a date to be fixed by registry.